importance of IPR or intellectual property rights for startups? What is the importance? What is the function of a trademark? What are the types of intellectual property rights that you might encounter? How do you choose a mark? How do you choose the right mark? So what is copyright? Copyright is the next category of intellectual property right. And then we'll discuss what is patentable, what is not patentable, and what is the significance of doing a search.
First, scholars, entrepreneurs, and my dear students, a very warm welcome to one of you gathered here. It's my greatest pleasure to welcome all of you to this RUSA-funded workshop on intellectual property rights and procedures for protection. In today's fast-paced and innovation-driven world, safeguarding intellectual assets is not just a necessity, but a strategic advantage. So this workshop aims to equip researchers, scholars, academicians, entrepreneurs, and the students with crucial insights into IP protection, patent filing, trademarks, and copyright laws, ensuring that innovative ideas receive the recognition and security they deserve. We are privileged to have with us Advocate Parvati Prasannan, a renowned expert in intellectual property law, who will share her knowledge and practical experience to help us navigate the complexities of intellectual property rights. I am confident that today's discussions will be enriching and will foster a deeper understanding of how to protect, manage, and commercialize intellectual property effectively. So to formally inaugurate this session and share his insights, it is an honor to invite Dr. Cyriac Tom Valakil, Chief Technical Officer of Panelist Nanotech Private Limited, to deliver the welcome address. Please, sir.
Okay, patents. You hear about patents all the time. What does that mean? So, does it mean that if you get a patent, you can use it? What do you think? You get a patent on which field are you working in?
I'm a student.
Student, yeah. What's your interest? No interest? That's bad. You should have some passion. Always. Actually, everyone should have passion. That's something I always push my students. Only with passion you can innovate something. And when you innovate, you want to protect that. That's where the patent rights comes in. Just getting a patent doesn't mean that you can use it. It can be a dependent patent. If you're independent patent, is okay. Most patents will be dependent. Let's say, example of pen. Back in 2000 years back, people were using feather to write. Let's say somebody has an idea 2000 years back. I can develop like a tool where I can put some ink in and write continuously, because feather you have to dip one sentence or one word and dip again. So let's somebody develop an idea, so we can fill that ink in the feather and write continuous write. So he gets a patent. Next guy comes with the idea of ball pen. Same idea, but ball pen with balls on it. And you can write it much faster. You also get a patent. But if the first person got a patent saying an equipment to continuously write on a page, on a paper, the second patent on the ball pen, it will be dependent on the first patent. Probably you can correct me, no?
So it's already disclosed. It's already disclosed.
Oh, that's correct. So the ball pen will get a patent, but he has to go to the first guy, get a license. So that's something you need to watch for. When you file the claim, you should make sure that they are mostly, if possible, independent. It's not easy to get, but if you get, then you are the best person. You will be controlling the crossroad. Actually, I call it crossroad patent. It's like a junction. When you want to cross it, you have to pay money to it. So when you look into an idea, see whether it can make it a independent patent out of it. That's where innovation comes in. We Indians are very smart, but we don't use our mind. That's a big problem. In college, or in school, we learn a lot of things by heart, put good exam, get good grades. What's the use of it? Not much. You have to understand what you are learning, and then you can use that. In fact, I'm proud to say I have 64 years patents as far. And I got those patents only because I understood what I'm doing. For me, chemistry is my passion. I'm a person who left medicine and joined chemistry. But today, I'm proud to say there's hardly any competition globally in the field I'm working in. The startup that I have here, I have 4 startups in India. That's Panis Nanotech. We beat NASA on the technology, on air purification. Today, we have the technology 2 generations ahead of what NASA is using today. So that's the power we have. We Indians are very smart, but we don't dare to do it. So I'm glad to see a lot of excellence here. And also faculty also. You have to inculcate the students. You are very powerful. Only you are not realizing your power. So faculty also push them. Make them work on some new things. Because just learning by heart is not something. Challenge them in the class, question them. Put some new topic on the board. Let them discuss it. So just look in theory. I'm sure you have some ideas that you are working on. Put the idea on the board. Let them discuss with the students. Somebody will have some idea. And you can also collaborate with the students, develop the idea, put it on the market. So there are a lot of, I'm again iterating the point. We Indians, particularly Malayalis, are very smart. I had the opportunity to work in research, top in research in Germany, America, Saudi, China, Russia. None of the places where I had actually the top of the cream was working with me. None of them were as good as me. And if you look at it in the US, in Indian population only 2 to 3%. Look at technical field, 30-35% are Indians. And in the US, it's very common that you hire and fire. You hire the people and fire them. After 2 years, just fire them. When I was working with Philips in the US I worked for 8 years there. During these 8 years, there were almost every year there's layoff. If people hire and after 2 years or 3 years, just lay them off. During my 8-year tenure at Philips, not a single Indian was laid off. Because we are so smart, they cannot lay off. Once you lay off, that group is gone. Because we are the pillars of the technology pillars of each group. So we are very smart, recognize your power and utilize that. So with that, I would like to say, today we have the great opportunity to learn from Ms. Pavadi how we can, in fact, another thing also we need to learn is how to formulate a patent. When you go to attorney, they are not subject specific, because they know how to formulate it in legal language. You have to write the patent yourself, and they put the legal framework to it. So the better you give them, faster, better they can formulate. Because they can only modify the input you are giving. So, like writing a literature, scientific publication, you have to really formulate what you're doing, why you're doing, what are the competition. All this you have to really write down and then go to the patent attorney. And they will then formulate and make the patent. So, and the claims, that's where the attorney comes in. Writing claim is legal language. And only, okay, I also try to do some of the claims, but final claims will come from the attorney. So, patenting is nothing much different than writing a scientific publication. Only we are trying to protect your idea. Publication, anybody can use it. Only patent, as I mentioned, if you say it will stop others using it. That's the main point, actually. This doesn't mean that you can use it. Only you can stop somebody else using your idea. With that, I would like to hand over the podium to Ms. Pavadi. So, in fact, I'm really proud to say you're here because some of my patents also, proud is handling some of my patents also. We had a lot of conversation on email and telephone. We are meeting for the first time. It's 3 years, 4 years, right?
I think more than 4 years, almost
Correct.
4 years, yeah.
Yeah, but
Very
we never
surprised
met.
to meet you.
That's today's world, right? Yeah. So, to
Thank
you,
you,
Mr.
thank you,
Gopal.
thank you very much.
We are honored to welcome Advocate Pavati Prasannan, a distinguished intellectual property attorney and a University of Kerala Gold Medalist and first rank holder in both LLB and LLM. With over 2 decades of expertise, she has been an integral part of Putran and Associates since 2006, heading the firm's Bangalore and Kerala operations. Specializing in trademarks, patents, industrial designs, and corporate laws, Advocate Pavati actively assists corporate clients in securing and managing their domestic and intellectual property portfolios international as well. Her extensive experience includes IP due diligence, licensing, dispute resolution, and contract drafting. Beyond legal practice, she is deeply committed to IP awareness and education, frequently conducting seminars and training sessions for universities, research institutions, and industry forums. It is with immense pleasure that I welcome Advocate Pavati Prasannan to lead today's session. Ma'am, please.
Thank you. Thanks. Thank you very much. If I can quickly know, thank you very much, Jyoti, for the kind introduction. Pleasure to see you all. I see a lot of women on the on the audience, which is even more encouraging to me because I represent a law firm, Putran and Associates, which is actually an all women law firm. All of us in all 4 offices are women lawyers. We have engineers who are men who work with us in terms of patents, but the lawyers are all women. So we believe in women empowerment. So I'm very happy to see a lot of women on the as part of the audience as well. Now, if I can quickly know what is the background of each one of you? Are you startups? Are you students? Are you entrepreneurs? Faculties? If I can just quickly know what do you all do, so that I can speak accordingly. How many startups here? Okay. You are based here. Okay. And students? Okay. Great. Thank you. And faculty? All right. Okay. Great. Have you ever attended these kind of seminars before, or is it a first time you attended before? Okay. So, once again, the whole idea of this particular session is to give you, I don't know what is the kind of time that I have today, but I've divided my sessions into 2. The first session where I'll try to give you an overview of intellectual property rights. What exactly is IP? What are the different kinds of IP? Because the most common difficulty that we face when we address clients' queries are the clients are not able to understand what is the difference between each kind of IP. People say design patent, people say utility patent, it's all different. So the whole idea of the first session is to give you an overview of the different kinds of IP. So I hope after the first session, you will have a clear-cut idea of what each intellectual property right is and how you identify one from the other. So if you have an idea, or if you have a concept, if you have something that you have created on your own, are you able to identify whether it is a trademark, whether it is a patent, copyright or design? That is the whole idea of the first session. The second session, I will focus on patents, give you an overview of what is patentable, what is not patentable, how do you identify a patentable invention, and if you feel something is patentable, how do you protect it, and what is the nature of the protection that you get, whether it is territorial, national, international, all these things will be covered in the second session. So just to give you a quick introduction about my firm, we are based in Chennai. We were established in 2004, run by Malayalis. There are 4 of us as partners in the firm. We have a team of about 25 engineers, about 6 patent agents. I have one of my patent agents here, Vidya, with me. About 25 plus lawyers and other paralegal staff. We have offices in Trivandrum, Bangalore, Kochi and Chennai. I represent the offices, I am in charge of the offices in Bangalore and Trivandrum. Now, the basic mission of our firm itself is to inspire, enable, and protect innovation, which is why we do a lot of pro bono activities in terms of giving awareness on intellectual property rights, especially in universities and other industry forums. Now, so we believe, as I said earlier, we were established in 2004. We believe in absolutely and completely ethical legal practice. We believe in proactive response. You send an email to us, you'll get a response in 24 hours for sure. We have a strong client base. We represent clients across the world. We have associate law firms across the world that we associate with. So you want to file a patent or a trademark or an intellectual property right anywhere in the world, we can help you. Uh, um, and we do a complete coverage of all aspects of intellectual property rights, anything related to IP, litigation, licensing, protection of intellectual property rights, trademarks, patents, copyrights, designs, geographical indications, trade secrets, anything licensing, anything related to IP is handled by us. We have a global network of associates across the world, and we have local presence in Chennai, where the intellectual property office of India is. One of the intellectual property office of India is in Chennai, so we have a local presence there as well. This is a leadership team. The firm was established by Elizabeth Putran. Elizabeth has about 25 plus years of experience in intellectual property rights. Putran is a managing partner of the firm. I and Amina are partners in the firm. I have been associated with Putran and Associates since 2006 when I started IP practice. And I've been heading the offices in Kerala and Bangalore since then. So let's quickly move on to the topic. What exactly is intellectual property right? I'm sure this is a question that you must have heard answered a lot of time. What exactly is an intellectual property right? Can anyone give me a quick? I just want to make it, interactive so that I don't have to speak all the time. Some rest for me as well. What is an intellectual property right? Can anyone explain? Intellectual property as a word itself means is a property that comes out of your intellect. It is the creation of your mind, right? And just like, so what happens when you have a real property? Real property is like a house or a piece of land that you have. Intellectual property is also like that. So if you have a piece of land, what do you do with that? You'll probably build a fence around it, right? Why? Because you don't want somebody to trespass into it. Then let's say, for example, you will build a house on it. You'll give it on rent, right? You can lease your property to somebody so that you get money out of it. Similarly, so what do you normally do? You will maintain your property, because only if you maintain your real property or your real estate, it will generate value for you. Right? In the same way, intellectual property also has to be maintained, it has to be protected, and it has to be developed if it has to give value to me. Otherwise, it is just a piece of paper. Your patent or your trademark or whatever is only a piece of paper. Unless you develop it, you use it, you maintain it, only then it will realize value for you. Now, what is the importance for intellectual property rights for entrepreneurs? So, I understand that there are startups here. So, what is the importance of IPR or intellectual property rights for startups? Now, what happens when you're a startup, a startup is, in most of the cases, your focus will always be on business development, right? You'll be interested in, raising funds, probably, product development and all of that. And what happens is that intellectual property rights will always take a sidestep. You'll forget about your intellectual property rights, which basically is the most important, valuable asset of your company, right? So if you look at probably 20 years back, right, the largest companies, the assets of the biggest companies in the world would have been factories or, probably their land and all of that. But if you look at the companies now, what is their biggest asset? Their biggest asset is not factories. Their biggest asset is not land or the offices. Their biggest asset is their intellectual property, right? Let's say, for example, you take a company like Uber or Zomato or Swiggy, their asset is all in their intellectual property rights. So as a startup, what happens is that the biggest mistake that I would say a startup makes is that they sideline intellectual property right. They sideline protection of intellectual property right. It is very important that you protect your intellectual property right at the right time. Another mistake that we have realized over the time is that startups knowingly or unknowingly may infringe somebody else's intellectual property right. So if you're launching a product into the market, you should always be aware of what are you launching, what is it already protected by somebody else. So knowing or unknowing infringement of somebody else's intellectual property right is also a mistake that startups often make. So all these are very important things to understand when you are entering into a startup business. And the most important fundamental principle of law, ignorance of law is not an excuse. You cannot say that I was not aware of law. That is not an excuse. So if you infringe somebody else's property, then it is an infringement. You can be penalized for it. So all these, kind of highlight the importance of protecting intellectual property rights. First of all, understanding what your intellectual property right is, what is the eligibility for protection for it, and how to protect it, and how to make sure that you are not infringing on third party rights. This is why IPRs and protection of IPR is very important for startups. So I would always suggest a startup, whenever startup is, I've worked with startups, people, students who have just come out of their college, having a lot of ideas in their mind. And I always ask them to invest, at least some of their effort and money and time on protecting their intellectual property. That investment has to be made at the right time. And when is the right time? It is always when you have the idea in mind. That is the right time when the idea has to be protected. So it's very important that startups invest in intellectual property right at the right time, so that you make your invention attractive to investors. See, when you have let's say, a good portfolio, a well protected portfolio of patents or trademarks or designs, it always makes your business attractive to investors. So having a portfolio of patents or intellectual property rights also makes your business attractive to investors. So it is very important that you identify, you realize the importance of IPR, take the necessary steps to protect it at the right time, so that you can eventually develop your business. So now, what are these intellectual property rights? So as a startup, or as any business, or as probably, a researcher, what are the types of intellectual property rights that you might encounter, that you might, let's say for example, you have an idea in mind, what are the intellectual property rights that can be generated out of that particular idea? But these are the different intellectual property rights: trademarks, industrial designs, patents, copyrights, geographical indications, and trade secrets. So we will discuss each of these in detail in the coming slides. So when we talk about protecting intellectual property rights, how do you protect your intellectual property right? You have to protect your intellectual property rights by disclosing it to the Government of India, and then getting a registration. You have to follow the process prescribed by the Government of India, or the laws relating to intellectual property rights, and you have to get a registration for it, right? Now how do you, and where do you file these applications? Let's say if it's a trademark that you want to register, or a patent that you want to register, or a design that you want to register, where do you file it? You have to file it in any one of the Government of India intellectual property offices in India. So Government of India has trademark offices, we call them trademarks registry, in 5 different locations: Chennai, Mumbai, Delhi, Kolkata and Ahmedabad. Patent offices in 4 locations: Chennai, Mumbai, Delhi and Kolkata. Copyrights office, there is only one copyright office where you can apply and get registration for your copyrights, which is in Delhi. The designs office, where you apply for design registration, is in Kolkata. There is only one design office which is in Kolkata, and the geographical indications registry is in Chennai. So this is where you have to file your respective applications. If I have a patent, then I will probably choose my patent to be filed in Chennai. Now how do you differentiate the jurisdiction of each of these offices? It depends on where the applicant is. So if, let's say for example, if Panelist wants to file a patent application, because Panelist is an address in South India, the territorial jurisdiction for Panelist to file a patent application would be in Chennai. So the different offices, but your protection will always be, the grant will always be for the whole of India, but the jurisdiction, the proper office with the jurisdiction to file will depend on the address of the applicant, and that will be Chennai. Now, I am sure all of you must have seen all these logos, right? So all these are trademarks. Right? What is a trademark? A trademark can be a name, it can be a symbol, it can be a logo, it can be even a signature, it can be a color, it can be any of these, it can be a slogan, right? So when I say I am loving it, you immediately know that it is McDonald's, right? So slogans can be this thing. Sachin Tendulkar's signature itself is a registered trademark. So signatures can be registered trademarks. Packaging, if you see the packaging on products, right? For example, this packaging of Pepsi, this is a registered trademark, because that packaging, that color combination and the way Pepsi is written inside, that particular logo is unique to the Pepsi Incorporated company. So that becomes their registered trademark. Have you seen this? chocolate, what is that? Hershey's chocolate. The shape of the Hershey's chocolate is a registered trademark of the company. So, the shape of a product can also, so only they can manufacture chocolates by that particular shape. So, shape can also be a registered trademark. The 3-pointed star symbol, the moment you see it on a car, you know it comes from Mercedes, right. So, all these are trademarks, packaging, product packaging, sound, we will come to sound trademarks later. So, these trademarks, this first categories of trademarks are called conventional trademarks, that is old school categories of trademarks, names, logos, everything that you use to distinguish your product. Now, what are the second categories of trademarks? These are called non-traditional trademarks. An example is sound. A sound can be a trademark. Can you give me an example? Anyone switched on Netflix? You hear a tadam sound, right? That is a registered trademark of Netflix. Tom and Jerry cartoons, this roaring sound of a lion that you hear, that is a registered trademark of MGM Studios. So, sound can also be a registered trademark. This is a very famous luxury brand of shoes called Christian Louboutin. The Christian Louboutin has got a registration for red color on the sole of their shoes. So, only Christian Louboutin can manufacture shoes with red color on the sole. So, red color itself is a trademark, right. So, these are all registered trademarks. There is also movement trademark or motion trademark. Any example? Have you seen the old Nokia phones? When you switch on the Nokia phone, you will see two hands coming together to form a handshake, right. That movement of hands coming together to form a handshake is a registered trademark. So, movement can also be a trademark. Lamborghini cars have a unique way in which their doors open, like the upward opening motion of the Lamborghini cars, that is also a registered trademark. So, all of these, so color, sound, a signature, motion, shape, all these can be also registered as trademarks, provided it is very unique to the company or unique to that particular product. So, as long as you can prove that this particular motion or this particular color or sound is unique to my company and people associate it with my product, I can get a registration for those as a trademark. So, these are examples of what we call non-conventional trademarks. Now, people often confuse between trademark and trade name, right. Your trade name is not your trademark. What is a trade name? Trade name is the name of your company. Let us say for example, Anand Milk Union Limited would be a trade name, but it is not a trademark. The trademark of the company is Amul. So, brand name is also called trademark, that is different from trade name or the business name of the company. So, that differentiation should always be there. What is the purpose of a trademark? The trademark will always identify the source from which it is coming from. So, if you see Amul, you know that it is coming from Anand Milk Union Limited. So, that is the fundamental principle or the purpose of a trademark. Of trademarks, what is the importance, what is the function of a trademark for the business? So, let us say for example, you are going to a supermarket, you want to buy chocolates. How do you identify which is the brand of chocolate that you want? From the name, right, from the product packaging. Let us say you want to buy a Lindt chocolate. How do you identify Lindt chocolate from Nestle? By the name of the chocolate, by the product packaging. So, the fundamental function of a trademark is to identify the source of the product. Where does that product come from? Right? That source identification is the primary function of a trademark. That is why trademark is very important for any business, because your product is identified to your company because of the trademark or the trade dress. We also call it a trade dress or the product packaging that you see on it. It also assures quality, right? When you see, let us say for example, when you see a Lindt chocolate or a Mars chocolate, you know that it has a certain level of quality when compared to a different brand. So, a trademark is also an assurance of the quality of a particular brand, right? And it also is a culmination of the goodwill that the particular company has acquired over the years. Now, coming to the important part, how do you register trademarks? Now, you have a trademark, you have a name that you have coined or made for your product. How do you protect that trademark? You protect your trademark by applying for the registration of that trademark. And where do you apply for its registration? You have to apply for registration in any of the 5 trademark offices that we discussed earlier. So, you file an application. Now, another common mistake that a lot of companies make is they choose names. The common mistake in choosing names is that they choose names which are very similar to somebody else's trademark. You will never get a registration for a trademark if your trademark is similar to or identical to an already existing brand, which is why it is always important to first do a trademark search to identify whether your particular brand is available for registration. There are two advantages for doing it. One is when you do a search, you will know who all have already registered. Not just identical marks, even similar marks. If there are similar marks on record also, your registration can be refused. So it is important to understand. So by doing a search, you can understand which are the similar marks already there, already registered by someone, already applied for registration by someone. You can also understand whether you are infringing somebody else's registered trademark. Right. For example, if you launch a product into the market with, let's say, a new name without doing a trademark search, you probably might be infringing on somebody else's registered trademark. So that search aspect of trademark is very important. One is to knock out the fact that you're not infringing a third party right. Secondly, to understand whether your trademark itself is eligible for registration. So that is why the trademark search is very important. It is a public search, anyone can do it. Just log into the government, you don't need to even log in, just need to go into the Government of India website, go to their trademark page. There's a public search facility where you can give your trademark, and do a public search and find out whether somebody else has already applied or registered for a trademark. So once you have done that, clearance, you've got a clearance that your trademark is available for registration. The next step is filing of trademark application. So you file an application for a registration of the trademark in any one of the 5 trademark offices in India. And once you file the application, Government of India will allot a number to you, following which it will examine your application. Now, what is this examination process? The examination process is one whereby the trademark office will assess whether your trademark is eligible for registration. Now, not all names are eligible for registration. Let's say, for example, if I start a business, let's say an edutech software, and I name it Parvati, will I get a registration for Parvati? No, because you will not get registration. Not all trademarks are eligible for it. You can use it. I can start a company by the name, I can brand my product as Parvati, but I may not get a registration for it because Parvati is a common name. It is a personal name. Now, what is the whole idea or significance or logic behind trademark registration? The logic is that once you get a registration, you are given the exclusive rights to use that brand. So, if I get exclusive rights to use the name Parvati, which means nobody else can use it. So, which is why the trademark office or the Government of India will not give you registration for very common names or very generic names, very descriptive names which are commonly used in that particular field, or personal names. All these are not eligible for registration. So, that assessment is done at this stage, that is examination, where the trademark office will assess your application, and then the trademark office will also do a search in its database to find out if somebody else has already applied for registration of that trademark. So that is something that you can assess at the time of before filing the application itself. So if your application is eligible for registration, the trademark office will publish it in a journal, which is a Government of India publication, which happens every week, every Monday, I think. It is available on the Government of India website. Now, this publication of a trademark application is basically to let the public know that somebody has applied for a registration of this trademark and we have accepted it. Now, if anybody from the public or any third party has an opposition against, has an objection to the grant of registration to it, they can file an opposition against the trademark. Now, this opposition period is 4 months, 4 months from the date of publication. So, if nobody opposes your application after it is published, it will automatically proceed to registration. So, any trademark application that you file has to go through all these steps to be able to proceed to registration. So, this is a fundamental or the basic process that a trademark application has to follow, the course of action that it has to follow to proceed to registration. Now, this is I think this is one of the most important slides that probably all of you should be aware of. How do you choose a mark? How do you choose the right mark? A lot of companies, tend to choose, in my experience, very common names, generic names that will, very clearly resonate with their product or their service. I will never advise that because it is very difficult to get a registration for a very common name or a descriptive name. So this is kind of a distinctiveness spectrum which will help you understand what is the kind of trademarks that you should choose, right, for your business or your product or your service. Now, on the right hand side of the spectrum, you will see the most distinctive or the more distinctive category of trademarks. So, if you look at the first trademark, which is Haagen-Dazs or Kit Kat, what is the significance of these trademarks? Kit Kat. Any meaning on that? Is there a meaning for the word Kit Kat? There is no meaning. Kit Kat is a coined word. We call it coined word or invented word because whoever made that trademark invented it. There is no meaning for that trademark. So, invented words or coined words are considered the most distinctive category of trademarks and eligible for registration because the trademark has no dictionary meaning. The trademark was invented by the applicant or whoever coined it, right. So, the most distinctive and most eligible category of trademarks are fanciful trademarks. We call them fanciful trademarks or invented trademarks which do not have a dictionary meaning. Now, the next category of trademarks, slightly less distinctive but still eligible for registration, are called arbitrary trademarks. Now, what are arbitrary trademarks? Arbitrary trademarks are words that have a meaning, but they have nothing to do with the product or the service on which it is used. A classic example is apple, right? Apple is a fruit, but what is it used on? Computers and mobile phones, right? So, apple is also an example. Cycle for agarbattis, right? That is also an example of an arbitrary trademark. So, arbitrary trademarks are words that have a dictionary meaning, but they have no reference or no link to the product or the service that you are using it on. They are also eligible for registration, right. Now, the next category is called suggestive trademarks. Suggestive trademarks are trademarks which when you hear you will know that okay, this has got something to do with this. Let us say for example Ujala, right. When you hear the word Ujala, you might think that oh, this could be a a fabric whitener or a whitening preparation, right, because it says Ujala. So, those trademarks are called suggestive trademarks, that the words when you hear it might suggest the nature of your product or your service. They are not eligible for registration, right. The last category is generic trademarks or highly descriptive trademarks. For example, if you have a carpet cleaning company and you are naming it carpet cleaning company, your brand itself is carpet cleaning, it is a very generic name, they are also not eligible for registration. So, when you are choosing a brand name for your business, always go for the right hand side of the spectrum. Choose either a fanciful name or an arbitrary name. Do a search and find out whether your name is eligible for registration, whether somebody else already has a registration for an identical or a very similar name, and only then start the business or start using the trademark. Apply for a trademark registration because the whole process will take a lot of time. If you apply for registration of a trademark now, probably it will take definitely at least a year to get a registration of the trademark. So, start early. The moment you decide, choose your trademark, do the search, do the clearance, make sure that it is on the, it's a distinctive trademark, apply for registration and let the procedure, the registration procedure takes its own course. So, this is all about trademarks. Any questions on trademarks? Any doubts? Nothing? Yes, sir. I'm sorry? Huh.
That is actually a common name, Lakshmi.
Okay, that's a very good question. Now, common names, let's say for example a name like this, Burger King is almost like that. Burger King also has a registration. Now, common names are eligible for registration if the applicant is able to show that he has been using it for a very long time and he has acquired a certain level of goodwill and reputation that people have started associating with it. So, today I can apply for Burger King. Burger King is already registered, but I am saying if I apply for Jayalakshmi Silks today, Jayalakshmi Silks is an already registered brand, but if I apply for Jayalakshmi Silks today, my chances of getting a registration are very high because provided I prove by way of documentary evidence and affidavit that I have been using it for the past, let us say 35 years, and I show sales bills, my advertisement figures and all of that, and I prove to the trademark office that people have come to associate this brand. It is a very common mark, it is a personal name, but people have come to associate that brand with me. But if they had applied for registration when they started the business, let us say I am only going to launch the brand now, let us say I have been using the brand only for 5 months, At that stage, they will never get a registration because it's a common word. Jayalakshmi Silks is a very common word because it's a personal name. Because silks is basically is not the trademark. The word silks is their product, right? The trademark is Jayalakshmi. So Jayalakshmi right now, or probably 5 or 6 years of use and having established a goodwill, if they apply for registration, they will get a registration for the trademark. So this category of trademark can get registration. Even this, for example, American Airlines is also a registered trademark. American Airlines is a very descriptive trademark. But because they were able to show that it is very popular, people have started using it. So which is why for a lot of clients also we give the same advice. Like when they come to us, if they feel that the trademark is a very generic name, very common name, and they are only about to start the business, but they don't want to change the name. Some clients are like that. I want this name. I don't want to change the name. So we tell them, okay, this trademark will not go through to registration because it is a very generic name. You can use it. You can use a trademark without registration. Let's say after 1 or 2 years, 2 or 3 years, if you can show that you have attained a certain level of goodwill and reputation, file an application at that point of time. You wait till you can show some sales figures and advertisements and all of that, and then apply for registration for the same brand. You might get a registration for the trademark.
നമ്മൾ ബിസിനസ് തുടങ്ങുന്നതിന് മുമ്പ് ട്രേഡ് മാർക്കിന് അപ്ലൈ ചെയ്യാം. സോ ഇൻ കേസ് ഞാൻ ആപ്ലിക്കേഷൻ കൊടുത്തു, എനിക്കത് രജിസ്റ്റർ ചെയ്ത് കിട്ടി, ഞാൻ ബിസിനസ് മുന്നോട്ട് പോയില്ല, ക്യാൻസൽ ആകും?
ഇല്ല, നമ്മൾ വിചാരിച്ചാലേ അത് ക്യാൻസൽ ആവുള്ളൂ. യു ഹാവ് ടു
സ്റ്റോറി ലേബർ ഇന്ത്യ എന്ന് പറയുന്ന പബ്ലിക്കേഷൻ ഓൾറെഡി രജിസ്റ്റേർഡ് ആയിട്ടുള്ള ട്രേഡ് മാർക്ക് അൺയൂസ്ഡ് ആയിട്ടുള്ള ഒരു ട്രേഡ് നെയിം വേറെ വാങ്ങിക്കുകയാണ് ചെയ്തത്.
Okay, that is a different, Labor India case is a different case. See, trademark registration, that is a very fundamental aspect of trademarks that she has raised. If we have the time, I will quickly explain that. See, there are a lot of companies that will apply for trademark registration and probably get a registration also without using it. മനസ്സിലായി, അതിന് നമ്മൾ ഡിഫെൻസീവ് രജിസ്ട്രേഷൻ എന്ന് പറയും. അത് ദേ ഹാവ് നോ ഇൻറ്റൻഷൻ ടു യൂസ് എ ട്രേഡ് മാർക്ക്, ബട്ട് ചുമ്മാ ഫയൽ ചെയ്ത് രജിസ്റ്റർ ചെയ്തിടും. നോ വാട്ട് ഈസ് ദ ഡിഫിക്കൽട്ടി ഓർ വാട്ട് ഈസ് ദ what do you call the consequence of that? Nobody else will be allowed to use that trademark. Nobody else will get a registration for the trademark also. But this person is sitting in this trademark is sitting in the register of trademarks without being used by anyone, without being used by the owner of the trademark also. Now, the Trademark Office, the Trademarks Act requires that if you have a registration for a trademark, you have to mandatorily use it. If you don't use a trademark for 5 years and 3 months after you have got a registration for your trademark, then you are liable to be removed. Your registration is liable to be removed for non-use. And നമ്മൾ non-use cancellation proceedings എന്ന് പറയും. മനസ്സിലായോ? അപ്പോൾ നോൺ യൂസ് ക്യാൻസലേഷൻ പ്രൊസീഡിങ്ങിന് നമ്മൾ ലയബിൾ ആണ്. ബട്ട് ദാറ്റ് നോൺ യൂസ് ക്യാൻസലേഷൻ പ്രൊസീഡിംഗ് വിൽ ഹാവ് ടു ബി ഫൈൽഡ് ബൈ എ തേർഡ് പാർട്ടി. സോ ലെറ്റ്സ് സേ ഫോർ എക്സാമ്പിൾ, ഇഫ് ലേബർ ഇന്ത്യ is on the register of trademarks, Labor India owner is not using Labor India for, let's say, has not used it for 5 years and 3 months after it has been registered, but I want to use Labor India as a trademark because I know that this person is not using it. I can either approach him and ask him for a voluntary license, you give me a license, I can use his trademark, I will give you a royalty for this particular trademark. If he does not agree to that, I can apply to the Trademark Office for a cancellation of his trademark registration. Right? And then if the Trademark Office, if I am able to prove that this party owner of the trademark has not used the trademark despite getting a registration for more than 5 years and 3 months, then I can cancel his trademark and then apply for the trademark myself. So this is a fundamental principle because the law is giving you a registration of a trademark, you have to actually use it. If you don't use it, you are liable to be, your registration is liable to be cancelled. But the window is 5 years. But that is also a common proceeding that we do. For example, there are a lot of cases. Recently, one Zomato or case, have you? Zepto, sorry, Zomato or Zepto. Zepto had a recent case. I'm not sure how many of you have read that case. Zepto had applied for registration of their trademark Zepto. So somebody else filed an opposition against that particular trademark, saying that I already have a registration for that trademark. So the person who opposed the registration of the trademark apparently had a registration for Zepto mark like 10 years back, but he has not used that trademark. So when Zepto applied for registration of the trademark, he opposed it, right? And when Zepto approached him, he said, you give me like a huge sum of money, I'll give you the trademark. Zepto did not agree. What did Zepto do? Zepto realized that he has got a registration for that trademark for more than, which is not in use for more than 5 years. So Zepto filed a cancellation of that trademark, for which they got a favorable order. So the old registration was cancelled and Zepto's application went through to registration. So it is important that even if you have a registration for a trademark, you have to use it. If you are not using it, your registration can be cancelled. Now next is, shall we move on to copyright? I'm sorry? Cost, madam, will depend on who the applicant is. Now, Government of India has a lot of schemes where they have reduced the cost for startups, which are the other categories, startups and MSMEs. So, startups and MSMEs, your government fees is 4,500, attorney's fees will be separate. For all other entities, trademark application fees is 9,000. That is the only government fee that you need to pay. But if you are engaging a lawyer, their fees for each of those steps will be there in addition. But anyways, it will definitely, any lawyer that you contact will not charge you more than probably 15,000 for a trademark up to registration. Yes, sir?
Madam, ആദ്യം SBT ഉണ്ടായിരുന്നു. SBI ഉണ്ടായിരുന്നു. പിന്നെ website SBI.
Ade.
How does this work with the government agencies?
It doesn't matter who the applicant is. I don't know whether SBT registration is still maintained. As far as I know, it is still maintained. What these companies normally do is, they will show some random use of the trademark. എന്തെങ്കിലും ഒരു flyer ഒക്കെ അടിച്ചിറക്കും. Something to show that the trademark is in use. Because, see, the burden of proof is on the person applying for cancellation. അവർക്കല്ല. ആൻഡ് ഒരിക്കൽ ഒരു ട്രേഡ്മാർക്ക് രജിസ്ട്രേഷൻ കിട്ടിക്കഴിഞ്ഞാൽ എപ്പോഴും എന്താ പറയുക, വെയിറ്റേജ് ഇസ് ഓൾവേസ് ഫോർ ദറ്റ് രജിസ്റ്റേർഡ് ട്രേഡ്മാർക്ക്. ക്യാൻസലേഷൻ അപ്ലൈ ചെയ്യുന്ന ആൾക്കാണ് ബർഡൻ ഓഫ് പ്രൂഫ് എന്ന് പറയും. അത് പ്രൂവ് ചെയ്യാനായിട്ട് ദാറ്റ് ഇറ്റ് ഇസ് നോട്ട് ഇൻ യൂസ്. സോ ഇഫ് ദ പാർട്ടി ഹു ഹസ് രജിസ്റ്റേർഡ് ദ ട്രേഡ്മാർക്ക് ക്യാൻ ഷോ സം യൂസ്, സം മാർജിനൽ യൂസ് ഓഫ് ദ ട്രേഡ്മാർക്ക് ഇൻ ദ ലാസ്റ്റ് 5 years ക്യാൻസൽ ചെയ്യാൻ പറ്റില്ല. അപ്പോൾ SBT, I don't know whether SBT is still maintaining the registration. എൻ്റെ അണ്ടർസ്റ്റാൻഡിംഗിൽ they are still maintaining the registration, but they are not using SBT. They are using only SBI, but they have registrations for SBT. But it is probably after 5 years, it might be cancelled by a third party. Somebody else will have to apply and get a cancellation for that trademark. But see, അങ്ങനെ ഒരു cancellation proceeding ആരായിരിക്കും ഇടുന്നത്? Somebody who will want to apply for SBT, അല്ലേ? അങ്ങനെ ഒരു മാർക്ക് SBT ഞാൻ അപ്ലൈ ചെയ്തിട്ട് എനിക്ക് രജിസ്ട്രേഷൻ കിട്ടിയാലും SBI can always come and challenge my use, saying that SBT and SBI are similar. അപ്പോൾ അതിനുള്ള ചാൻസസ് കുറവാണെന്ന് പറയാം. Okay, so shall we move on to copyright? Okay, so what is copyright? Copyright is the next category of intellectual property right. Now, each of these intellectual property right will protect different things, right? Now, what does copyright protect? Copyright protect any literary, dramatic or musical works that you have created. നിങ്ങൾ എഴുതിയ ഒരു poem or let's say something, a dance that you choreographed can be protected by copyright. Any artistic work, if you draw a logo or if you have created a cartoon image, all those can be registered and protected by copyright. Computer programs are also categorized as copyright protectable works in India. Computer programs per se, we will discuss that in more detail when we discuss the patent related slides, because there is a lot of confusion around what is patentable in computer programs and what is not. So, computer programs per se or algorithms are copyright protectable work in India. Cinematographic films mean videos can be protected as copyright. Sound recordings are also protected as copyright. So, a simple example പറയുകയാണെങ്കിൽ, if you take a song, നമ്മൾ എപ്പോഴും പറയും song in copyright. See, if you take a song, the song will have multiple copyrights in it. It is not single copyright. Let's say, for example, if you take a song from a movie sung by Yeshudas, അതിൻ്റെ അകത്ത് പല rights വരും. The first right is the lyrics, right? Lyrics will come under literary work. That probably will belong to one person, the person who actually wrote the song. Then there is അതിൻ്റെ musical notation. There will be an underlying musical notation to it. That will come under musical work. That probably will be owned by Ilayaraja or whoever composed the music for that. That's a separate literary work. പിന്നെ എന്താണ്, this song will be recorded in a studio, അല്ലേ? And eventually ആ ഒരു song recording ഉണ്ടല്ലോ, that recording will have a separate copyright. That is a sound recording. This probably will be, the recording of the song will probably be owned by the recording studio, let's say T-Series or whoever has recorded that particular music. So, angane if you take a song itself and let's say that song is picturized in a video, in an album, a musical video, that album, the video of the album will have a separate copyright. So a song eduthu kazhinjal that itself will have multiple copyrights. So copyright will always be a copyright ennu parayunnathu is a bundle of different rights ennu venengil we can say. And the fundamental what do you call aspect that differentiates copyright from all other intellectual property right is that copyright is a sui generis right. Sui generis right ennu paranjal is a right that is automatically created. Automatically created ennu paranjal the moment I create it I have copyright. So nammal when you read books, when you see websites, you will see inside a circle alle saying see copyright 2024 ennu ezhudiyal what does that mean? That does not necessarily mean that it is a registered copyright. It is because copyright is automatic. Even if you don't register your copyright also, the moment you transfer your idea into a tangible medium, your copyright is automatic. So you can put C inside a circle. Adesamayam trademark you can't put R inside a circle unless your trademark is registered. Trademarks R inside a circle kandittille. That you can put only if it is a registered trademark. If you don't have a registration for your trademark, you can use only TM. Right. Adesamayam copyright la if you see C inside a circle, it need not necessarily be a registered copyright because copyright la registration is not mandatory. The moment you create your work and it is transferred onto a tangible medium, your copyright is automatic. Now what is the fundamental idea behind copyright? A word la thanne undu. You cannot copy. So copyright is a right that ensures that nobody else can copy what you have. So copyright means that you shall not steal from somebody else. Now I will give you a simple example of how copyright works. Let's say for example there's a cricket match happening in a stadium and two reporters are sent to cover the match, right? And both of them cover the match, they write an article on that particular match. Obviously the thread of the write-up will be the same. Let's say if it's a match between India and Australia, okay, these people, this is the score and this is how the match ended. So the underlying thread of their write-up will probably be the same, right? But each person will have a independent copyright on what he has written. The reason is that there is no copyright on an idea. There is no copyright in a concept. The copyright is always in how you express your idea. So that is the fundamental difference or the fundamental aspect of copyright. Copyright exists in something that you have originally created. So if I have created something and you have also created something, even if the underlying idea is the same, we both will have separate copyright in the work because both are original creations, right? I did not have access to her work, but if she can show that I had access to her work and I have copied verbatim from her report, then it is infringement of copyright. But if I can show that what I have written is my original creativity, even if the underlying concept is the same, each person can have independent copyright over the work. So the whole idea of copyright is that your work should be original. So if you have created something original, it's your original creativity, then you are eligible for copyright. That is why in lot of this usually happens in movies, right? Movies the underlying thread of the story will be the same. But a script writer, two script writers can write totally different scripts based on that, and each person can claim copyright on his own work. It becomes infringement or copying of one only if one can show that the other is a verbatim copy. So in copyright infringement cases, it is very tricky. It is for what usually happens in copyright infringement cases is that it's very subjective. We usually depend on the judge. The judge will have to literally sit and assess both the works, and if he feels that one is a verbatim copy of the other, only then it becomes infringement. Otherwise both people will have independent copyright on their own original creativity. So like I said earlier, procedure for registration, copyright registration is not mandatory. Why? Because it is automatic. So even if you don't register your copyright also, if you can show that as on this date you have created this work, you are eligible for protection. But you can still register copyright. This usually copyright is registered by the script writers, because they usually write a script. They'll probably go to multiple directors or actors. Their script is disclosed to people. They don't want them to copy it and then make a movie with the help of somebody else. So all these people in the movie field usually register their copyright. Now, how do you register copyright? You can file an application, and where do you file it? You file it before the Government of India Copyright Office, which is in Delhi. You file an application, very pretty simple process, copyright registration. The Copyright Office will examine your application. If it is eligible for registration, it will register it, and this signifies a copyright, does not mean a registered copyright. If you claim, so if you write something, if you create something, just put C inside a circle to show that you own rights or copyright in that particular this thing. It is also important to put a copyright notice. We call this a copyright notice. This is basically to show to the public that you are claiming some rights in it. See, when you do not have a registration for a copyright, it is always advisable to put a copyright notice, basically to inform the public that this belongs to somebody. We discussed trademark registration. This registrations a validity period. So, it is not indefinite, right. So, when you register a trademark, your protection is valid for 10 years, right, and this 10 years starts from the date of your application filing, and then every 10th year you can renew the registration of your trademark. So, you file an application, you get a registration probably in 1 year's time, but at the 10th year time period you have to renew the registration. Similarly, copyright also has a validity period, but trademark in indefinite you can renew. Like the 10th year you renew for another 10 years, the next 10th year, 20th year you can renew it for another 20 years like that, I mean another 10 years like that. Copyright stops at a certain period of time. What is the validity for copyright? Copyright validity is 60 years from the date of death of the author. Author is the person who created that work. So, 60 years from the date of death of the author. After 60 years, it will become public domain. So, that is why lot of these Disney characters, Walt Disney marichu കഴിഞ്ഞിട്ട് I think it's more than 60 years now. So, Disney characters probably some of them have come into public domain because the validity of copyright starts from is actually 60 years from the date of death of the author. Now, for cinematographic work, sound recording, photographs, etc., it is 60 years from the date of publication of the work. And what is the advantage that you have when you get a registration of a copyright? If somebody else copies your work, you have two options. You can file a civil suit for copyright infringement. Copyright infringement is also a criminal offence. A criminal case can also be filed against the infringer. Now, we will quickly move on to the next intellectual property right, which is very closely related to patents. It is called industrial designs. So, people often call it design patent. There is no design patent in India. Design patent another concept is in the US. In India, it is either patents or industrial designs. Now, what is a design? Design is an intellectual property right that relates to or that connects to the external shape or configuration or aesthetic features of an article. Let us say for example, this chair, I have designed a new chair. Okay. Now, there is no functional aspect in this chair, the way it functions, it is not ergonometric, nothing. This is just a uniquely designed chair where I have created some unique shape of the chair here. If this is a unique shape, if I can show that nobody else has manufactured a chair like this, I can get a registration for that. So, it is called industrial design. So, industrial design relates to the IP that relates to the shape or configuration or external appearance of an article. It can be any article of manufacture. It can be a phone, it can be a glass, it can be a bottle, it can be a chair, it can be a watch, it can be anything, the external appearance. So, if you have something new, if you have designed something new where the newness of the article is in the external appearance and not in the functionality, then you may be eligible for a design registration. Okay. Now, what are the examples of a design? Any of these can be registered as, let us say for example, you have designed a new model of a car, a new model of a headlight. There are a lot of EV companies, our clients, EV companies that file for, let us say for example, if you take a car or a scooter, right, each part of that scooter or a car may have some design and may be eligible for design registration. So, a lot of design applications are now being filed for headlight designs, right, design of tail lamps, designs of headlamps, design of the scooter as such can be protected by industrial designs, shape of a chair, shape of a lamp, anything. If you have designed something new which you think is not available for or which is not used by anyone, you may be eligible for a design registration. Even designs on tiles can be registered as industrial designs. Now, what is the criteria for design registration? The criteria for design registration is pretty much the same as patent registration. That is, your design has to be absolutely new. It should not have been used or disclosed by anyone anywhere in the world for you to be able to get a registration for a design in India. So, absolute newness or absolute novelty is a criteria for design registration. And secondly, your design should not have anything to do with the function of the article. See, if it is a functional aspect, then it becomes a patent. It is a different intellectual property right. So, if the design is related to just the aesthetic appearance or the shape or configuration of the article, then you can, let us say for example, the shape of a cooker, a new design of a cooker can be registered as a design in India. And it has to be a part, an integral part of the article itself. And where do you file a design registration? You can apply for design registration in any of the design office, any of the design office or not. There is only one design office in India, which is in Calcutta. It is actually the patent office in Calcutta which functions also as a designs office. So, design applications have to be filed before the designs office in Calcutta. And how do you apply for design registration? You file an application. So, to show your design, what do you give? You can give either computer graphic images of your design, or you can give line drawings of your article, or you can give photographs of your article also, but you have to show the article from all different angles. So, they have to be a top view, a bottom view, a side view, a perspective view, very clear photographs, so that the examiner who is at the designs office examining your application will get a clear picture, because it is not possible for you to take the article there and show the designs office that this is what the article is. So, your images have to be very clear when you apply for a design registration. So, designs office will examine the application, it will see if there are any prior designs, similar designs already registered by someone, then you will not be eligible for design registration. So, they will examine the application. If the application, they feel that the design is eligible for registration, they will give you a registration for the design. And what is the validity of a registered design? It is total 15 years. So, the first protection is for 10 years, and then you can extend it for another 5 years. So, 15 years is a total protection time for a design in India. I will quickly move to trade secret, because trade secret is something that there is a lot of discussions around trade secret. Now, what is a trade secret? Anyone knows what is a trade secret? Yeah, any information. It can be any information or anything that a company wants to keep a secret, right? Now, see, what have we understood now? If you want to register something, if you want to protect your intellectual property right, what do you have to do? You have to disclose it, right? If it is a design, you have to give the photographs. If it is a patent, you have to give a complete detailed disclosure of your invention. Trademark also, you have to disclose your trademark to the government of India. But there are certain information, certain things, certain intellectual property rights, the company may want to keep it a secret. The company does not want to disclose it to anyone. What do? They will keep it as a trade secret. Now, is there any protection for trade secret? No, there is no registration for trade secret. There is no way you can give the trade secret to the government of India and ask them to keep it a secret. No, there is no registration. So, the protection for trade secret depends on how well you keep it a secret. So, there are different ways in which companies, and there is no law. There is no law in India that will help you protect your trade secret also. So, how do companies normally protect their trade secrets? How do they maintain their trade secret? It will probably be known only to very few people in the company. Let us say if it is a recipe, like she said, probably it will be known only to 2 people in the company. It will not be disclosed to anyone else. The recipe, the formula probably would be stored in a vault, which is not accessible to the others in the company. And then let us say for example, to make that to make that particular product using that recipe, obviously it has to be disclosed to the manufacturer, right? You have to disclose it to the people in the factory, and they will all be tied up with contracts or non-disclosure agreements. So, how well does the company maintain the secrecy will depend on how long your trade secret is trade secret is protected. So, the moment the secrecy is lost, your trade secret is not a trade secret anymore. So, any example of trade secret anyone can give? KFC, Coca-Cola, adallade nammal eppozhum kekkunnalle. Huh? McDonald's, yeah, to a certain extent. Google the search algorithm is a trade secret. Google the search algorithm nobody knows. That is also a trade secret. New York Times bestseller nu kettitttundo. Bestseller avare bestseller choose cheyyunna oru criteria undu. that criteria is also a trade secret. അങ്ങനെ കുറേ trade secrets ഉണ്ട്, but trade secrets are not registrable അല്ല, they cannot be protected. It depends on the company to maintain the secrecy of this thing. Now trade secrets are very common in companies like masalas. We have a client who is into very popular masala brand here, I mean spices brand here. Their recipe for a certain masala is a trade secret. They have not disclosed it to anyone. It is known only to 2 people in the company, very well protected. It is disclosed to some people in the factories, some manufacturers, but they have confidentiality agreements that bind them. So they cannot disclose it to anyone. So how well do you protect your trade secret will depend the extent to which you can protect your trade secret. So if you are, let's say for example, so how do you enforce your trade secret? If that person breaches confidentiality, then it is a breach of agreement, but there is no other law to, it's only breach of contract that can be enforced against that particular person for breach of confidential information. So these are the different ways in which you label information as confidential. You don't give access to, let's say for example, if it's a database, if it is served in a database, companies restrict access to databases, servers and computer programs. They ensure that access is password protected. It is known only to very few people. A lot of companies educate their employees as to, these information are secret, they should not be divulged to any third party. And then companies also ask employees to sign non-disclosure agreements, which a lot of startups also do now. Now these are the different types of confidentiality agreements. I don't want to get into all those details. IP assignments agreements also I think can be skipped. Now another important category of intellectual property right is your social media accounts. See, these are also very, because a lot of business happens around the digital space now, right? So your social media accounts, your domain name, right? There are a lot of instances that we are facing now, especially in terms of domain name disputes, because people will copy your domain name, people will copy your trademark and use it, get a registration as a domain name. So your domain names, your social media accounts, your company name are all important aspects of your intellectual property rights, which also needs to be protected. So if you have a domain name, let's say for example, if you have a brand name, and your company name is different, probably your website will have a different domain name, need not necessarily be your trademark, right? But it's always advisable to block the domain names, because you will not want somebody else to start a domain name and a website which bears your trademark. Because when you apply for domain name registration, the domain registrar will not check and search in the trademark database, need not necessarily check in the trademark database. So if you don't want somebody else to misuse your trademark, your brand name and use it as a domain name and have a website link to it, probably you should block popular domain names or popular extensions of your domain names which relate to your patents. Your social media accounts are also very important. A word of caution in that sense is that, see, when you use social media accounts or websites, we have, a lot of our clients have received legal notices from companies saying that the website content is copied from somebody else. So you have to be very careful when you create your websites, because your website developer may probably have taken content from some other website. That is a very clear case of copyright infringement. Anything that you see on the website, anything that you see on the internet is not free for use. So if you use content from a third party website on your website, you might probably be infringing a third party's copyright or some other right, intellectual property right belonging to a third party. So it's very important that you maintain your social media accounts, your social media posts, the content on your website. You have to monitor them, make sure that you are not infringing on a third party's intellectual property right. This is just a, I'm not sure how many startups are aware of this. The Government of India has a lot of schemes that helps startups protect their intellectual property rights. The most important one being the IP facilitation scheme for startups, which actually helps startups to file patents, trademarks, design applications at much lesser costs where you can choose one of the Government of India approved facilitators for filing your patents, where the government will pay the facilitator their fees and the startup will incur only the government fees for filing the patent application. So, the facilitation scheme is something, if you want to know more information about it, you can contact me. My firm is also a Government of India approved startup facilitator, but you need to have a DPIIT certificate of recognition as a startup to avail the startup the startup facilitation scheme of the Government of India. The advantage is that the cost of the facilitator, which means my professional fees, will be paid by the government. The company will have to incur only the government fees for filing the patent application. Another important developments that have occurred in the past few years is expedited examination. See, in patents, the most difficulty that we have is, the delay in processing of patents. So, you can expedite your patent application if you are an MSME startup, or if there is a woman applicant in the list of applicants also, you can expedite your application, which means, you can get a patent granted in like about probably 1.5 years to 2 years, 1.5 to 2 years, you should be able to get a patent granted if you apply for expedited examination. So, again, reduction of fees for startups and MSMEs, government institutions, educational institutions, all these categories have reduced fees for filing patent application. Yes, something very important, like I said earlier, few mistakes, top 10 mistakes or top few mistakes that you can avoid in terms of protection of your IP. One is, like I said earlier, very important that you have a very clear-cut strategy for protection of your IP. Identify, when you start a business itself, you identify what are the intellectual property rights that need protection, strategize which is most important, which is to be filed when. That strategizing is very important. So, have a very clear-cut strategy in terms of protecting IP the moment you start your business. Then the second point, something that we discussed in the beginning, as a startup, your focus will always be on, a lot of other things, investment and all of that, but don't ignore these things, filing of patents, filing of trademarks or designs are not to be ignored. Secondly, third point, improper document foundation. See, everything that is something that we will discuss when we discuss the patent session next. Finally, the do-it-yourself approach to patents. See, lot of companies, startups including, think that patent is something that you can, or patent or a design application or a trademark is something that I can do on my own. It is possible, but I will never recommend that, because how you draft your specification, how you prepare and file your design application, all this is very important. So, do-it-yourself approach may help you sometimes, but when you try to enforce your patent, enforce your design registration, so enforce your IP against a third party, you might have some challenges depending on how you have drafted the specifications. It's always advisable to reach out to professional help when you are preparing and filing your patent applications or any intellectual property applications. So, any questions on this? എന്തോ Okay, open source ആണെങ്കിൽ you can copyright it. Open source in the restriction is only in licensing. See, what you have created is your copyright. It is only your licensing terms will be governed by the original license of your open source software that you have used. അത് മറ്റേ GNU license ആണെങ്കിൽ your licensing terms will depend on the original code that you have used. Licensing il maatrame restriction ullu. You cannot have a different licensing term than the licensing term of the open source software that you have used. നമ്മൾ ക്രിയേറ്റ് ചെയ്ത വർക്കിൽ you can claim copyright.
ഒരാൾ പബ്ലിഷ് ചെയ്യുന്ന റിസർച്ച് ആർട്ടിക്കിളിന്റെ കോപ്പിറൈറ്റ് ഷെയർഡാണ് ജേർണലുമായി.
Okay, copyright automatic ആണ്. So, if let's say for example you have an article, a research article which you have published, automatically it is your copyright. അത് registration എടുക്കേണ്ട കാര്യമില്ല. But it's already public information. Our research article, probably if the research article contains information that is eligible for patent, അത് ഫയൽ ചെയ്യാൻ പറ്റൂല, or a design, അത് നിങ്ങൾക്ക് ഫയൽ ചെയ്യാൻ പറ്റൂല, but you can claim copyright. It's your copyright.
ക്രിയേറ്റീവ് കോമൺ ലൈസൻസ് എന്ന് ചില
ആ.
ആർട്ടിക്കിൾ കാണും. അത്
അത് ഈ പറഞ്ഞ ഓപ്പൺ സോഴ്സിൻ്റെ കാറ്റഗറിയിൽ വരും. ക്രിയേറ്റീവ് കോമൺസ് എന്ന് പറയുന്നത് ഇറ്റ് ക്യാൻ ബി യൂസ്ഡ് ബൈ എനി വൺ. ക്രിയേറ്റീവ് കോമൺസ് ലൈസൻസ്, GNU GPL ലൈസൻസ്, ദീസ് ആർ ഓൾ ലൈസൻസസ് വിച്ച് വിൽ അലൗ യു ടു സി IP-യുടെ ദ ഫണ്ടമെൻ്റൽസ് ഓഫ് IP എന്താണ്? ഞാൻ ഉണ്ടാക്കിയ സാധനത്തിന് only I have rights to use it. If you want to use it, you have to get a license from me. I have to allow you to use that, but I will not give it to you for free. I will probably charge you. You give me royalty for each instance of your use എന്ന് എനിക്ക് വേണമെങ്കിൽ പറയാം. Creative Commons license, GNU GPL licenses are all licenses which will allow you to freely use the content. പക്ഷേ അത് ഉപയോഗിച്ച് നമ്മളൊരു ഡെറിവേറ്റീവ് വർക്ക് എന്ന് പറയും. യു ക്രിയേറ്റ് എ ഡെറിവേറ്റീവ് വർക്ക്, യു ക്യാൻ ക്ലെയിം റൈറ്റ്സ് ഓൺ ദ ഡെറിവേറ്റീവ് വർക്ക്. പക്ഷേ if you have to license your derivative work to somebody else, that derivative work should also be governed by the same license as the Creative Commons license. അത്രയേ ഉള്ളൂ. You will have copyright on your derivative work.
പറഞ്ഞില്ലേ നിങ്ങളൊരു പേജ് ഡിസ്നിയുടെ കാര്യമാണ്.
ഹാ.
ക്രിയേറ്റ് ചെയ്ത ഇമേജ് പർട്ടിക്കുലർ ഡിസൈൻ 60 years after the death പബ്ലിക് ഡൊമൈനിൽ വരുന്നു. അത് ആക്ച്വലി പിന്നെ ആർക്കെങ്കിലും പേറ്റന്റ് ചെയ്യാൻ പറ്റും?
പറ്റൂല. ബിക്കോസ് പേറ്റൻറ്റോ കോപ്പിറൈറ്റ് എടുക്കാമോ എന്ന് ചോദിച്ചാൽ, സി ദാറ്റ് ഇസ് ഇപ്പോൾ ഫോർ എക്സാമ്പിൾ ക്യാരക്ടർ ലൈക്ക് മിക്കി മൗസ്. സി അതിൻ്റെ കോപ്പിറൈറ്റ് മാറുന്നില്ല. ഇറ്റ് ഈസ് ജസ്റ്റ് ദാറ്റ് അതിൻ്റെ പ്രൊട്ടക്ഷൻ മാറുന്നു. സി ഇഫ് ഐ ക്രിയേറ്റ് എ ന്യൂ ഇമേജ് ഓഫ് എ മൗസ്, if it does not look like Mickey Mouse, I can claim a separate copyright over it. ഡിസ്നി പോലത്തെ കമ്പനീസ്, ഡിസ്നിയുടെ കാര്യം പറഞ്ഞുകൊണ്ട് ഞാൻ പറയാം, ഡിസ്നി മരിച്ചിട്ട് ഇറ്റ്സ് മോർ ദാൻ 60 years അല്ലേ, വാൾട്ട് ഡിസ്നി മരിച്ചിട്ട്. സോ ഐഡിയലി ഓൾ ഹിസ് ക്യാരക്ടേഴ്സ് ആർ നൗ ഇൻ ദ പബ്ലിക് ഡൊമെയിൻ ബിക്കോസ് ദ കോപ്പിറൈറ്റ് term has expired. So now technically we all should be able to use it. എനിക്ക് നാളെ ടീഷർട്ട് ഡിസ്നിയുടെ പടം വെച്ചിട്ട് ഇറക്കാം വേണമെങ്കിൽ. പക്ഷേ അങ്ങനെയല്ല. സോ വാട്ട് ഡിസ്നി ഹാസ് ഡൺ ഇസ്, because they knew that the copyright will expire, they have also taken registrations for trademark for all the characters. So if I use the Disney characters now on, let's say, my lunchbox or t-shirt and manufacture it, they can sue me for trademark infringement. Copyright ആണ് expire ആയത്.
maximum 15 years.
15 years ഉള്ളൂ. അത് കഴിഞ്ഞിട്ട് it will go to public domain. Yeah.
And regarding the legend power, actually the producer is the funder, right?
അത് എല്ലാം കോൺട്രാക്ച്വലാണ്. ഐഡിയലി എന്ന് പറയാൻ പറ്റില്ല. പ്രിഡോമിനൻ്റ്ലി നമ്മൾ കാണുന്നത് എങ്ങനെയാണെന്ന് വെച്ചാൽ, ലിറിസിസ്റ്റ്, മ്യൂസിക് കമ്പോസർ, സിംഗർ എന്നെല്ലാം ദ പ്രൊഡ്യൂസർ ഓഫ് ദ മൂവി വിൽ assign the rights. Let's say for example, you are a lyricist, right? You write music. Sir is a music composer. I am a producer. I am producing a movie and I want you to write a song. I want you to compose the music for that song, for that particular song. I will approach you. I'll say that this is a situation. You write a song for me, you compose a music for me. But I will have an agreement with you where you will assign all your copyright to me. You will also assign your copyright in the musical work to me. So ultimately the producer might own, but there are also instances where the right will still remain with it is all contractual. It depends on how you negotiate, how the producer has negotiated the. Correct, yeah. Okay, Ilayaraja case see, Ilayaraja will own the copyright only in the musical work, right? Ilayaraja is a musical composer. He has copyright only in the musical notations that he has created. Adinu oru challenge illa. He will probably lose it only if he has signed an agreement with the producer of a movie in which that song appears, where he says that I have given all my rights to you, or the sound recording company, either way. അങ്ങനെ അയാൾ അസൈൻ ചെയ്താൽ മാത്രമേ അയാൾക്ക് കോപ്പിറൈറ്റ് ഇല്ലാതാവുന്നുള്ളൂ. അതർവൈസ് ഹീ ക്യാൻ റീറ്റെയിൻ ദ കോപ്പിറൈറ്റ് ഇൻ ദ സോങ്. ഓക്കെ, എപ്പോഴാണ് ഞാൻ ഇളയരാജയുടെ മ്യൂസിക് ഇൻഫ്രിഞ്ച് ചെയ്യുന്നത്? ഇഫ് ഐ യൂസ് ദറ്റ് മ്യൂസിക് without his consent. Let's say for example, ഞാനൊരു ഗാനമേള ഓർഗനൈസ് ചെയ്യാണ്, ഒരു ഇവൻറ്റ് ഓർഗനൈസ് ചെയ്യാണ്. ആ ഇവൻറ്റിൽ ഐ എം പ്ലേയിങ് ഇളയരാജാസ് മ്യൂസിക്. ഇഫ് ഇളയരാജ കണ്ടിന്യൂസ് ടു ഓൺ rights in that song, in the musical composition, he can come and challenge my use, saying that you are infringing my copyright, I have not given you the license to use the song. But what if he has already assigned it to the producer? Then he has no rights to challenge me. Adonnu. Okay. Secondly, ഇളയരാജയുടെ മാത്രമല്ല, അതൊരു വളരെ കോംപ്ലിക്കേറ്റഡ് കേസാണ്. ഇളയരാജയുടെ കോപ്പിറൈറ്റ് മാത്രമല്ല അവിടെ ഇൻഫ്രിഞ്ച് ആവുന്നത്. ലെറ്റ്സ് സേ ഫോർ എക്സാമ്പിൾ ഐ ആം പ്ലേയിങ് ദാറ്റ് സോങ്. അപ്പോൾ ഞാൻ അവിടെ ഐ എം ഓൾസോ ഇൻഫ്രിഞ്ചിങ് ദ കോപ്പിറൈറ്റ് ഓഫ് ദ സൗണ്ട് റെക്കോർഡിംഗ്. അപ്പോൾ ദ സൗണ്ട് റെക്കോർഡിംഗ് കമ്പനി ക്യാൻ ഓൾസോ കം ആൻഡ് ചാലഞ്ച് മീ. ഒരു സിമ്പിൾ എക്സാമ്പിൾ പറയുകയാണെങ്കിൽ ലോട്ട് ഓഫ് കമ്പനീസ്, ഐ ഡോണ്ട് നോ ഇവിടെ അങ്ങനത്തെ ലീഗൽ നോട്ടീസസ് വന്നിട്ടുണ്ടോ എന്ന് എനിക്കറിയില്ല. ഇഫ് യു ഹാവ് എ പബ്ലിക് പ്ലേസ്, ലെറ്റ്സ് സേ ഫോർ എക്സാമ്പിൾ ഒന്നും വേണ്ട, ഇവിടെ ഇപ്പോൾ നിങ്ങളൊരു പാട്ടിടുക, അപ്പോൾ നമ്മൾ ഇത്രയും പേര് ഇവിടെ ഇരിക്കുക, ഇവിടെ ഒരു ബോക്സ് വെച്ചിട്ട് ഇഫ് യു ആർ പ്ലേയിങ് ലെറ്റ്സ് സേ ഇളയരാജാസ് മ്യൂസിക് ഓർ എനി movie song for that matter, you will probably be infringing the rights of the lyricist, you are infringing the rights of the music composer, the sound recording company, the producer. Ellardeyum rights ivada violate because this is communication to the public. I can hear it, എനിക്ക് എൻ്റെ വീട്ടിൻ്റെ അകത്ത് എൻ്റെ റൂമിൻ്റെ അകത്തിരുന്ന് പാട്ട് കേൾക്കുന്നതിൽ കുഴപ്പമില്ല. That is not infringement. But the moment I put it on the, let's say, the lobby of a hotel or lobby of a school or an office or a space like this, it is infringement.
What about reality shows? Reality shows.
Again same thing. അവരൊക്കെ ലൈസൻസ് എടുത്തിട്ടാണ് ചെയ്യുന്നത്. Everybody has taken license. That was the biggest issue that these channels faced when they started these reality shows, was that they started getting legal notices. Because ഈ reality showsil ഒരു ഡിഫറൻസ് ഉണ്ട്. Reality showsil they will have their own orchestra. Right, their own orchestra playing the song. So they are not using the sound recording. They are not using the recording of the song. So the recording companies cannot challenge them. But obviously the lyricist, because the lyricist in the part, one child is standing there and singing. The music composer and the music ആണ് അവിടെ വായിച്ചുകൊണ്ടിരിക്കുന്നത്. So you are infringing upon the music composer's copyright. The only copyright that probably won't be infringed when you are playing live music is sound recording. സൗണ്ട് റെക്കോർഡിങ്ങിൻ്റെ കോപ്പിറൈറ്റ് വയലേറ്റഡ് ആവത്തില്ല, ബട്ട് യു വിൽ പ്രോബ്ലി ബി ഇൻഫ്രിഞ്ചിങ് ഓൾ അതർ കോപ്പിറൈറ്റ്. അതാണ് ഞാൻ പറഞ്ഞത്, ഒരു സോങ് എന്ന് പറയുമ്പോൾ ഇസ് എ ബണ്ടിൽ ഓഫ് കോപ്പിറൈറ്റ്സ്. സോ ഹൗ യു യൂസ് ഇറ്റ് വിൽ ഡിസൈഡ് വിച്ച് ഇസ് ദ കോപ്പിറൈറ്റ് ദറ്റ് യു ആർ ഇൻഫ്രിഞ്ചിങ്. ഇവിടെ ഞാനൊരു സൗണ്ട് റെക്കോർഡിംഗ് വെക്കുകയാണ്, ആ പാട്ടിൻ്റെ സൗണ്ട് റെക്കോർഡിംഗ് ഞാൻ പ്ലേ ചെയ്യുകയാണെങ്കിൽ ദെൻ ഐ ആം ഇൻഫ്രിഞ്ചിങ് എവറിത്തിങ്, എവറി റൈറ്റ്. അതിൽ ഒരു ഡി മിനിമസ് പ്രിൻസിപ്പിൾ എന്ന് പറഞ്ഞൊരു, ഇപ്പോൾ ഫോർ എക്സാമ്പിൾ ഇൻസ്റ്റാഗ്രാമിൽ നിങ്ങൾ റീൽസ് കാണുമ്പോൾ എല്ലാത്തിലും സിനിമ പാട്ടാണല്ലോ അല്ലേ. അതൊക്കെ എത്ര നേരമുള്ളത്? 30 സെക്കൻഡ്സേ കാണുകയുള്ളൂ. അതിനൊരു ഡി മിനിമസ് പ്രിൻസിപ്പിൾ, അത് ദാറ്റ് ഇസ് നോട്ട് ഒരു എന്താ പറയുക, ഒരു ലീഗൽ പ്രിൻസിപ്പിൾ ഒന്നുമല്ല, ദാറ്റ് ഇസ് കോപ്പിറൈറ്റ് ലോയിലൊന്നും അത് പറയുന്നില്ല. ബട്ട് ദർ ആർ ലോട്ട് ഓഫ് ജഡ്ജ്മെൻറ്റ്സ് വെയർ ഇറ്റ് ഹസ് ബീൻ ഹെൽഡ് ദാറ്റ് ഇഫ് ദ യൂസ് ഇസ് വെരി മിനിമൽ, let's say for example 10 seconds to 30 seconds ഒക്കെ ആണെങ്കിൽ ഇറ്റ് ഇസ് നോട്ട് ഇൻഫ്രിഞ്ച്മെൻറ്റ് എന്നൊരു റൂളിംഗ് ഉണ്ട്. അപ്പോൾ ആ ഡി മിനിമസ് പ്രിൻസിപ്പിളിൻ്റെ ബേസിസിലാണ് ഈ ചെറിയ ചെറിയ സാധനങ്ങളൊക്കെ എടുക്കുന്നത്. അതർവൈസ് ഈ കരോക്കി ഈസ് ഓൾസോ ഇൻഫ്രിഞ്ച്മെൻറ്റ്, ബിക്കോസ് കരോക്കിയിൽ ബാക്ക്ഗ്രൗണ്ടിൽ പ്ലേ ചെയ്യുന്നത് ഇസ് എ സൗണ്ട് റെക്കോർഡിംഗ്. സോ യു ആക്ച്വലി ഇൻഫ്രിഞ്ചിങ് ദ സൗണ്ട്, അതർവൈസ് യു ഹാവ് ടു ടേക്ക് എ ലൈസൻസ്. വെഡ്ഡിങ്സ്, ഈ റിലീജിയസ് ഓർഗനൈസേഷൻസിൻ്റെ ഇവൻറ്റ്സ്, ഇതിനൊക്കെ സോങ്സ് പ്ലേ ചെയ്യുന്നതിന് മാത്രമേ എക്സെപ്ഷൻ ഉള്ളൂ. ഫെയർ യൂസ് എന്ന് നമ്മൾ പറയും കോപ്പിറൈറ്റിൽ, വിച്ച് ഡസ് നോട്ട് എമൗണ്ട് ടു ഇൻഫ്രിഞ്ച്മെൻറ്റ്. ബാക്കി അല്ലാതെ എവിടെ നമ്മൾ സോങ്സ് പ്ലേ ചെയ്താലും ഇറ്റ് ക്യാൻ എമൗണ്ട് ടു ഇൻഫ്രിഞ്ച്മെൻറ്റ്, ബിക്കോസ് ഇറ്റ് എമൗണ്ട്സ് ടു കമ്മ്യൂണിക്കേഷൻ ടു ദ പബ്ലിക്. അതായത് എനിക്ക് കോപ്പിറൈറ്റ് ഉള്ള സാധനം ഐ ആം കമ്മ്യൂണിക്കേറ്റിംഗ് ടു ദ പബ്ലിക് വിത്തൗട്ട് യുവർ പെർമിഷൻ, എമൗണ്ട്സ് ടു ഇൻഫ്രിഞ്ച്മെൻറ്റ് ഓഫ് കോപ്പിറൈറ്റ്. This session will focus on patents, okay, because my understanding was that people wanted to know more about patents, what the filing procedure is, but I thought I'll give you an overview of all intellectual property rights and then focus on patents. Okay, so after this session I hope you will be able to identify what are patentable inventions, what are not patentable inventions, and how do you identify whether your invention is patentable or not. There are certain criteria, all those things we will discuss here, and also protecting patents nationally and internationally. I am not sure whether I discussed that in the previous session. IP rights are territorial, right? Territorial എന്ന് പറഞ്ഞാൽ എന്താണ്? your right is protected in the territory where you are protected, where you have registered. So, that is why we will discuss. So, when you talk about intellectual property right, there is always a national and international aspect to it, national and international aspect depending on where you want to register or protect your intellectual property rights. So, all those things in respect of patents is what we will cover in this particular session. Okay, so this is what we will discuss in this session. Innovation, ellarum kekkunna oru word aanu, right. So, we'll understand what exactly an innovation is, or innovation or invention is, and then we will discuss what is patentable, what is not patentable, and what is the significance of doing a search. Nammala trademark we discussed on prior art searches, right. Similarly, in patents also, I mean trademark availability searches. Similarly, in patents also, patent search is very important. So, we will discuss what is the importance of patent searches. Then we will go and into detail of what is the filing procedure, how do we file and register a patent in India, followed by international protection of patents. What is a patent? Patent is the intellectual property right that relates to inventions. And what is an innovation? Any idea? Innovation, right? If you look at innovation, all innovations are an improvement of something that is already there. All improvements, all inventions improvements. So, there is already something that is existing. People research on that, people develop on that and make improvements out of it, and each of those improvements could be inventions or innovations that are eligible for patents. So, the classic example of innovation I was discussing with Vidya, innovation. If you look at the development of wheels, how far we have improved. And where we have reached. So, our journey, our process of developing something from scratch, from what it was like, let us say 50 years back to what we have developed now, that journey is called innovation. Our journey the different aspects of products can be eligible for, may be eligible for patents depending on lot of criteria that you may have to satisfy or prove. So, patents are basically the intellectual property right that is applicable to inventions or innovations. Now, what is patent? Patent is a limited right, it is a monopolistic right. Unlike in other intellectual property rights, the patent gives you a monopoly right or a monopolistic right over your invention, but it is for a limited period of time. Patent is a limited right, unlike trademarks where you can indefinitely renew your registration and protect it and claim exclusivity over it. Unlike trademarks, patent is, and design also is limited. So, patent is an exclusive right, a monopolistic right, but it is limited for a certain period of time. And what does it give you? It gives you the exclusive right to manufacture, use, market, sell, import, export that particular product, right. And this particular right is a statutory right. What do you mean by a statutory right? A statutory right is a right that is conferred by a statute or an act, right. Copyright, what did we discuss in copyright? Copyright is automatic, sui generis. Patent is not sui generis. Patent is a patent. An invention becomes a patent only if the government of India grants you a patent. A grant there is no protection for the patent. So, that is statutory right, the right that is granted by law to you. So, patent is a statutory right and patent is a territorial right. And what is territorial right? It is protected within the territory of the country where you have got a grant for the patent. So, if you have a patent granted in India, it means your exclusivity, your exclusive rights, your protection is limited to the territory of India. So, if you want to protect your patent in a foreign country, then you have to file and get a patent in that country. Only then you will get all these rights in that particular foreign country. So, patent is a statutory right. There is no protection for an invention which is not patented, zero protection. It is a territorial right. And what is the fundamental logic behind patents? That is a difference with trade secret. See, trade secret I am keeping my invention a secret. I am not disclosing it to anyone. But for a patent, for me to get exclusive right, what do I have to do? I have to disclose my invention to the government of India. And what does the government of India do? That we will discuss in the coming slides. The government of India will make this information public. In the patent, all details will be made available to the public, but once it is granted, so public can see the information, see the extent of research that I have done in a particular field of science, right. But eventually when the patent is granted, I am given the exclusive right to use that invention. But what does that, how does that public information help others? Other researchers in the field can look into that document and they can develop further. So, the whole idea of patenting is to make patented information, patented inventions, the information relating to your research public information, so that others can develop further on that invention, so that innovation goes on. So, that is a fundamental what do you call logic or reasoning behind granting of patents, that you disclose your invention to the Government of India, and the Government of India gives you in return an exclusive monopolistic right over that invention, further encouraging others to research and develop further on that. Now, what are the laws in India that govern protection of patents? There is a government, there is a Patents Act of 1970 and the Patent Rules of 2003. These two acts, legislations are a whole system of patenting in a governed chain. And where do you file the patents? You can file your patent in any one of the Government of India patent offices which are located in Mumbai, Delhi, Chennai or Kolkata, depending on the place of your place of business or the applicant's place of business. Now, next the fundamental question, who can apply for a patent? For any invention, the first right in the invention belongs to the inventor, the person who has actually invented that invention. So, the first right to patent a product or a process belongs to the inventor of that particular product or a process. Now, what happens if the inventor, let us say is working in a company, right, and the inventor is an employee of a company. The inventor has developed that invention during the course of his employment in that particular company. Then who can apply for the patent? It is the company that can apply for the patent, because the company has hired the employee to do the research for the company. So, then what happens in such an application, the company will file the application, but the inventor who has actually worked on the invention will have to assign all his rights to the company. Only then can the company file an application. Similar is the case when you are a, let us say a research scholar in a university. You are using the university's funds, the university's facilities to do a research. In such cases also, the inventor will be the individual researchers, but the applicant of the patent will be the university. So, in that case also the inventor has to assign or give all his rights in the invention to the university or the company, and only then can the company apply for make an application for a grant of patent. And finally, if the inventor who has actually invented the product or the process is dead, then his legal representatives can also apply for a grant of patent. Now, this is the most fundamental question relating to patent, that is, how do you assess patent? You have an invention, you have an idea which you think can be developed into a unique product or a process. So, the question is it patentable or not? So, when you think about patentability, there are three fundamental questions that you need to answer, right? Three fundamental criteria. So, only if your invention satisfies these three criteria will your invention be eligible for a patent. So, that is the first thing that we assess. So, when an inventor comes to us for filing a patent or discloses an invention to us, the first thing that we assess is, does it satisfy these three criteria? The first one is called novelty. Novelty in what we discussed in design, that is, your invention or the technology that you have disclosed is not available or not published anywhere in the world. So, novelty means novelty across the world. So, you may be filing the patent application in India, right, but your invention has to be new not only within India, it has to be new across the world, because the patent office will search across the world to see if your invention is already a public information. So, novelty or newness across the world is a fundamental criteria or the first and foremost criteria for a grant of a patent. Now, the second criteria is called inventive step. Now, inventive step in the varnala, there has to be some technical advancement in your invention. See, if you look at any invention that you see now, it is always an improvement of something that is already there. You can't make something out of the thin air. Your invention is always a development of something that is already there. There is already something that is existing, you find a problem in that, you find a solution with the help of a new product or a new process, right. So, this this particular technology or this invention that makes your product different from the prior art or what is already there, there should be a technical advancement, there should be something that is not there, a technical advancement in your invention to be able to be eligible for a patent. Now, we also call it non-obviousness. Non-obviousness nu parnal your invention should not be obvious to a person who is skilled in that particular field. Right. Let us say for example, if the invention relates to cloud computing, a simple example, or you know, let us say blockchain technology. I have no idea about blockchain, I am not an expert in blockchain technology. So, when you come and disclose the invention to me, I might think that it is a very fantastic invention, but that is not the criteria. Your invention should not be obvious or very simple to a person who is skilled in that field of technology. So, the patent office will always assess the invention from the point of view of a person that is skilled in that field. So, if a person skilled in that particular technology feels that, oh, this is something that I could have also thought of, this is, then it becomes a non-patentable invention. So, it is a very subjective criteria, quite difficult to prove when this is raised by the examiners in the patent office. But this is a common objection that often comes also. So, inventiveness or that technical advancement is also something that needs to be proved in order to be eligible for patents. Now, the last criteria is industrial applicability. There has to be some application, some industrial use or industrial applicability for your patent application, otherwise it is not eligible for patent. Now, this criteria is also called usability or workability of your invention. Now, workability in parnal your invention should work. Right. Now, when you file a patent application, see how do you file a patent application? You have a product. A product, no, can we go to the patent office and show the product to the patent office to say that this will work? No, you cannot take the prototype and show them that this is how it will work, that cannot be done. So, it is all in writing. So, when the patent examiner reads your specification, he should be convinced that it will work the way you say it will work. Our working should be workability in the parayum. So, workability is also utility or workability of the invention is also a very important criteria for patentability. You should be able to convince the examiner that it will work as explained in the specification. Okay. So, these are the three criteria. This is our first assess. So, an invention comes to us, the first thing that we assess is novelty, inventiveness and industrial applicability criteria. Now, the second important aspect that we assess is whether the invention falls under the list of non-patentable inventions already listed in the Patents Act. See, the Patents Act section 3 of the Patents Act already lists down already gives a list of patents, inventions that are not eligible for patents. Now, our criteria we will inform the clients that see this might fall under section 3, so it is not eligible for patents. So, actually this is the first assessment that we do, we first assess section 3, because invention they will know either section 3 non-patent inventions. If it is a non-patentable invention as per section 3 itself, then we say there is no point doing the next assessment of novelty, etc. So, the first assessment is always related to whether your invention falls under the non-patentable inventions categories. Now, what are the list of non-patentable inventions? There are a lot of inventions that are categorized as non-patentable inventions. Anything that is contrary to natural laws, perpetual motion machine, file ida kittathilla, because the trademark office will not accept, because it will not be, it is contrary to natural laws. Anything that affects the damage or that will affect the health of atom bomb undakittu file idale, you will not get a registration. A bomb undakittu file idale, however inventive it is, novel it is, you will not get a registration, because it will be something that is harmful to the health of a living being. Another important thing is you have to differentiate between discovery and invention. Right. See, discovery is something that is already there in nature, you are only discovering it, that is not invention, that is different. So, discovery of a scientific principle or an abstract theory or discovery of a living thing or discovering something that is already existing in the nature is not an invention, because it is only a discovery. Invention is something that you create, you develop, so that is also not patentable invention. New form of a known substance, new form of a known substance in the something, let us say a particular compound is already existing in a certain form, right, and you invent or your innovation is that you discover or you develop a new form of that substance, but the substance remains the same, right. You are only developing a new form of a known substance and the property of X and property of Y is the same. Your invention is only a new form of that substance, that is also not a patentable invention. This probably is one of the most controversial provision of the Indian Patents Act. because there are a lot of cases around it. Novartis case ഒക്കെ വായിച്ചിട്ടുണ്ടോ? Novartis case എന്നൊക്കെ കേട്ടിട്ടുണ്ട്. Novartis case and all relates to new form of a known substance. Novartis cases-ലൊക്കെ see നമ്മൾ evergreening of patents എന്ന് പറയും. Have you heard of evergreening of patents? Evergreening of patents is something that these pharmaceutical companies do. What they do is they will probably get a patent for a drug, a chemical composition. So Novartis case is a very classic example of a new form of a known substance objection. That is, see, Novartis has got a patent for, Novartis is a Swiss pharmaceutical giant, multinational pharmaceutical company who invented a drug composition and got a patent for it. That drug is used for the treatment of a certain type of cancer. Now what Novartis did was that, see, patent is statutory, appo 20 years a protection ullu alle. So 20 years they have the exclusive rights to manufacture that product. So they have highly priced their medicine. They have been selling the product. What they did was at 20 year കഴിയാറായപ്പോൾ they filed a new patent application for the same drug but a new form of the same drug. അതായത് ആദ്യം ഉണ്ടായിരുന്ന ഫോം അല്ല, പക്ഷേ the compound is the same, the therapeutic effect is the same, എല്ലാം same ആണ്, but the only thing is the change in the form, and they applied for a patent. The Indian Patent Office rejected. ബാക്കി എല്ലാ കൺട്രീസിലും ഗ്രാൻറ്റ് ചെയ്തു, US-ലൊക്കെ ഗ്രാൻറ്റ് ചെയ്തു, but the Indian Patent Office rejected it because saying that you are basically evergreening your product. അതായത് ഒരു തവണ പേറ്റൻറ്റ് കിട്ടി, just to extend the patent, life of the patent and make sure that they have monopoly over that particular, life-saving drug. They extended the patent by filing a new form of a known substance, and the Patent Office rejected it. The case went up to the Supreme Court, but the Supreme Court also upheld the ruling of the Patent Office that patent cannot be granted because this is a clear case of a patent filed for a new form of a known substance. So that is also something that we commonly face when we apply for patents related to new form of a known substance. Admixture of two things. So there is a compound X, there is a compound Y. Compound X has a certain property, Y has a certain property. You just mix the two of them, and your new product, the mixture has a combined properties of these two. That is not a patentable invention. It can be eligible, it may be eligible for a patent if the combination has some additional therapeutic effect, something that is not known separately. Then it may be eligible for patent. Otherwise, if you are simply mixing two things, combining two things, then also it is not eligible for patent. Mere arrangement or rearrangement is also not eligible for patent. ഇല്ല, പ്രോസസ്സ് ആണെങ്കിൽ പ്രോസസ്സ് വരാം. ഇപ്പോൾ ഫോർ എക്സാമ്പിൾ ഈ വരുന്ന ഇത് തിരിച്ചാണ്, ഇതിൽ മെത്തേഡിന് പറ്റില്ല, പ്രോഡക്റ്റിന് പറ്റും. നേരത്തെ പറഞ്ഞതിൽ പ്രോസസ്സ്, ഫോർ എക്സാമ്പിൾ ഇഫ് യു സേ എ ന്യൂ ഫോം ഓഫ് എ നോൺ സബ്സ്റ്റൻസ് കനോട്ട് ബി ഫോർ എ പ്രോസസ്, ഇറ്റ് ഹാസ് ടു ബി ഫോർ എ പ്രോഡക്റ്റ് അല്ലേ. അതിൻ്റെ പ്രോസസ്സിന് വേണമെങ്കിൽ, പ്രോസസ് റിലേറ്റഡ് ക്ലെയിംസിന് മാത്രം വേണമെങ്കിൽ നമുക്ക് യു മേ ബി എലിജിബിൾ ഫോർ എ പേറ്റൻറ്റ്, ബട്ട് ദറ്റ് പ്രോഡക്റ്റ് വിച്ച് ഇസ് ഓൺലി എ ന്യൂ ഫോം ഓഫ് എ നോൺ സബ്സ്റ്റൻസിന് ആ ക്ലെയിമിന് റിജക്ഷൻ വരും, അങ്ങനെയേ ഉള്ളൂ. ബട്ട് ആ പ്രോസസ്സിന് പേറ്റൻറ്റ് കിട്ടിയത് കൊണ്ട് നമുക്ക് എന്താണ് അഡ്വാൻറ്റേജ് എന്നുള്ളത് ഇസ് എ ഡിഫറെൻറ്റ് ക്വസ്റ്റ്യൻ. I can use a different process. I can bypass it by manufacturing the same product using a different process also. Okay. Now this is method of treatment of curing a disease. So any method of treatment is not eligible for patent, but a medical diagnostic device or a medical device is eligible for patent. Medical devices patent eligible aanu, but a method of curing a disease is not eligible for a patent. Plants and animals cannot be patented. The most important thing, software per se. See that word per se is very important. Software thaniye, standalone patents is not eligible for standalone software is not eligible for patents in India. But if the software has a hardware element, if the software has a technical application, then it may be eligible for patents in India. Anything that comes under the category of copyright will also not be eligible for patent. Method of playing a game, mental act, all those things are not eligible for patent. All these come under copyright. That is why presentation of information, I am just gathering information from data from different places and then I am presenting it in a certain way. That is also not eligible for patent in India. Anything that part comes is a part of traditional knowledge. Traditional knowledge എന്ന് പറഞ്ഞാൽ നമ്മുടെ പഴയ ആയുർവേദിക് ടെക്സ്റ്റിലൊക്കെ എഴുതിയിട്ടുള്ള എന്തെങ്കിലും കാര്യങ്ങളാണെങ്കിൽ that is not also not eligible for patents. neem case, turmeric case ഒക്കെ കേട്ടിട്ടില്ലേ, അതെല്ലാം comes under this, where patents have been refused registration, patents have been applied for properties, therapeutic properties of neem and turmeric, but they were already disclosed in our Ayurvedic text. അപ്പോൾ അത് കോപ്പി ചെയ്യാതിരിക്കാൻ വേണ്ടിയിട്ട് the government of India has created the traditional knowledge digital library എന്ന് പറയും. അതായത് നമ്മളുടെ ട്രഡീഷണൽ ടെക്സ്റ്റിലുള്ള എല്ലാ ഇൻഫർമേഷനും കോഡിഫൈ ചെയ്തിട്ട് they have created a digital library. It is called TKDL. So now when patent examiners are faced with applications that relate to traditional knowledge, അതായത് ഏതെങ്കിലും ഒരു ഹെർബിൻ്റെ ഇലയുടെ ഒക്കെ പ്രോപ്പർട്ടീസ് disclose in the patents ആണെങ്കിൽ they will always refer to TKDL to see if this is already disclosed in any of the ancient texts. എന്നിട്ട് മാത്രമേ, only if it is new and if it is not covered by the traditional knowledge, they will be eligible, considered eligible for patent. Any invention relating to atomic energy is also not eligible for patents. Now, patent protection for computer software is probably one of the most high discussed concept in terms of patentability or patent eligibility. Now, see what happens when you file patent applications for computer software is that the examiner always has a tendency to reject it under section 3K of the Indian Patents Act, because section 3K very clearly says that a mathematical method or a business process or a computer program per se is not eligible for a patent application. So, if you disclose an invention in a patent application that relates to a computer software, then there may be objections on the basis of section 3K of the Patents Act. Having said that, there are several inventions that we have filed, my office itself has filed, where we have got grants for patents related to computer software. Now, the reason being that the software per se or the algorithm per se is not eligible for patent protection, but if your software has a technical application, or if your software has or gives a solution to a technical problem, or it has a technical application, then it may be eligible for a patent. Or 5 years back vare the patent office, the examiners were insisting on hardware component, that your software, only if it is attached to a hardware, and that hardware also had to be novel, only then it was eligible for patent application. Ipo anganeyalla, the latest the computer related inventions guidelines അനുസരിച്ച് software തനിയാണെങ്കിലും, if the software, you can prove that the software has a technical application, then it is eligible for patent protection. ഒരു simple example പറയാനാണെങ്കിൽ, if you are let us say a computer software that will help you book a movie ticket, right, may not be eligible for patent, because it is only helping you do a business, right. But a computer software that will increase the storage space in a computer, or make the storage space more efficient, or a computer software that will change or increase the shutter speed of a camera, those may be eligible for patent protection. A computer software that will probably help me slide and switch on my phone may also be eligible for a patent, because those are softwares that have a technical application, but a software that does not have a technical application may fall under the criteria of section 3K of the Patents Act. And the Patents Office has also focused, has also published what is called the computer related invention guidelines, which have to a large extent clarified as to what kind of computer related inventions or software related inventions are eligible for patents. Okay, so we are also, so when as Vidya is an expert here, when we draft software inventions, software related inventions, we are very careful. We always focus on the technical problem. നമ്മൾ ആൽഗോരിതത്തിൽ അല്ലെങ്കിൽ സോഫ്റ്റ്വെയറിൽ മാത്രം ഫോക്കസ് ചെയ്ത് കഴിഞ്ഞാൽ സെക്ഷൻ 3K ഒബ്ജെക്ഷൻസ് വരും. So when we draft a computer related invention or a software related invention, you have to always identify the technical problem. What is the technical problem that the software is addressing? Because the first question that the examiner will ask is, what is the technical problem? What is the technical solution that your software is identifying? If you are not able to identify that, then it will be rejected. So the question is, you identify how we draft a software related invention is that you identify a technical problem, you say what is a technical solution that the software offers, and then you give the examples of how the particular software makes improvements on that particular product or the process. That is how a software related invention can proceed to grant. So it also depends on how what exactly the software is and how we can present this information to the patent office. Okay, now some general precautions. I am assuming all of you are innovators, all of you have ideas, and all of you probably will be filing patents in future. So certain precautions that you need to keep in mind, because as researchers you have a tendency to always publish your paper, right. The publication is always what comes into your mind when you write something or when you have an idea in mind. So in patents you have to always keep in mind that novelty, right. Novelty is a fundamental criteria for patenting your invention. So if you publish your invention also, then it becomes non-eligible for patent. So it is very important that you do not publish your invention before you apply for a patent. So if you have an idea in mind, if you have a product or a process that you feel is eligible for patenting, then do not publish your invention. Wait till your patent application is filed. You get an opinion as to assess whether it is eligible for patent, and if you feel it is eligible for patent, file your invention first, file your application first, and then publish your patent application, because publishing an invention before filing a patent application can affect the patentability of your invention. You can obviously work it in a lab, you can do reasonable trial and all of that, that may not affect your patentability, but any public disclosure can affect the patentability of your invention. Now, a very important thing, conduct patent search, because see, novelty criteria is not something that is, because it's taken very seriously by the patent office. So before you invest money into filing and processing a patent application, always do a patent search to see if your invention is eligible for patents, to see if your invention is novel. That exercise is very important, because and secondly, it is always the first to file. Point, that is, patent is a statutory right. Patent becomes a patent, or an invention becomes a patent, a right. You have some right only if it is granted, granted patent by the patent office. So which is why your filing date is very important. In patents, it is always the first to file that has priority. For example, in 2 years I am doing a research on a certain technology. 2 years I am application file okay. I am filing an application. In today I am filing an application for that technology, but I have invented this 2 years back, assuming. Now, I file in 1 week if somebody files the same invention or probably the same set of claims, only he will get patent for it, because it is always the first way. Not even if I say that okay, I had this in mind much before, he may not be eligible for a I may not be eligible for a patent. So the filing date is very important. That's in patents, we always advise clients to file a patent as soon as your idea has taken a definite shape. You see, the research will take a lot of time, but you need not wait for the entire research to be complete to file a patent application. Our full research complete munne, you can file a patent application. I think we will discuss in the coming slides. Provisional patent application, that is, before your idea, when you know that your idea has taken a certain shape, and you know that this is going to be developed into this, you can file a patent application at that point of time, so that you don't lose out on the priority. You don't wait for the entire research and development to be complete, for the prototype to be ready to file a patent application. Don't do that. As soon as you know this is what your invention is going to be, just file a patent application, just file a provisional patent application, so that you get that particular filing date as early as possible. Now, some more information, like for example, what I think Siriak sir also said, always maintain records of your research work. See, we may not be, you are all inventors, so you will be the best person to explain the research to us. So your research papers, your documentation, your research work is very helpful for us to draft a specification. So always maintain records of your research work, because they help patent attorneys to draft the patent specification properly. Do not publish your invention before filing. We discussed that. File a patent application as early as possible. The do-it-yourself approach may not help you in patents, because patent is a techno-legal document. So always choose a patent attorney carefully and draft specification and claims very carefully. And finally, keep your patent application alive. See, even after you get a grant also, you have to maintain your patent. Patent protection is for 20 years, right? 20 years we maintain cheyyanam. Even after grant also, you have to pay annuity fees to the government of India to maintain your patent. And finally, patent just remains a piece of paper unless you commercially exploit your invention. So commercialization is also very important as far as patents is concerned. Now, we will quickly understand what is a patent search, because patent search is a very important exercise that we do when it comes to patent processing or patent filing. Now, there are different reasons why patent attorneys do searches, or different reasons why clients or researchers or inventors want to do patents also. We will study those first. Now, the first reason is patentability. You want to know, you have an invention in mind, you have an idea, you want to know whether it is eligible for patent, you will check, you will do a patent search to see if your patent is eligible, if your patent is novel, if somebody has already applied for a similar, somebody has already disclosed that information to the public. So, to check patentability of your own invention is the first reason that we do patent prior art searches. Secondly, a lot of researchers, see, research is happening in lot of cutting edge technologies, right. So, researcher may want to know what is the latest research in that particular field. So, to identify which is the closest prior art, lot of researchers do prior art searches. Thirdly, when you do a prior art search, what do you get? You understand what are the already existing patents in that field, what is the latest research in that particular field. So, I can modify my application, I can modify or redo my patent application and file a stronger application by highlighting the differences in my technology or my patent from what is already there, which will help me avoid objections in the future. So, doing a prior art search always helps you file a stronger application. Fourth point is something that we discussed earlier also in terms of trademarks, checking for infringement. Let us say for example, a company wants to launch a new product into the market, right. So, how do you know that this product is already covered by somebody else's patent? It could be subject of somebody else's patent also. So, it is very important. So, if it is already covered by somebody else's patent, the moment you launch the product into the market, you will be served with a infringement notice and then probably dragged into the court for a patent infringement suit also. So, a lot of companies do prior art searches to identify whether the product that they have invented or the process that they have invented before they launch it into the market, whether they are infringing on third party patents. We call it a freedom to operate search. Aditya search we call prior art searches. This category of searches is called freedom to operate search. Do I have the freedom to launch the product into the market? FTO also is done, is also done by a lot of companies before they launch their product into the market. Finally, a lot of companies do patent searches to understand their competitors' portfolio. Like for example, if I am Samsung, right, I will always want to know what is the research that Apple is doing in terms of mobile technology. Apple patents നോക്കിയാൽ മതി അല്ലേ, അവർ ചെയ്യുന്ന ലേറ്റസ്റ്റ് റിസർച്ച് വിൽ ബി സബ്ജക്റ്റ് ഓഫ് ദെയർ പേറ്റൻറ്റ് ആപ്ലിക്കേഷൻ. അതെല്ലാം പബ്ലിക് ഇൻഫർമേഷൻ ആയിരിക്കും. പേറ്റൻറ്റ് ഫയൽ ചെയ്ത് കഴിഞ്ഞാൽ ആഫ്റ്റർ എ സർട്ടൻ സ്റ്റേജ് ഇറ്റ് ഇസ് പബ്ലിക് ഇൻഫർമേഷൻ. സോ ഇഫ് ഐ വോണ്ട് ടു നോ വാട്ട് മൈ കോമ്പറ്റീറ്റേഴ്സ് ബിസിനസ് ഇസ്, വാട്ട് മൈ കോമ്പറ്റീറ്റേഴ്സ് latest research and development is, all I need to do is check for their patents. So, patent prior art searches are also done by companies to identify and understand the kind of research and development happening in their competitors' business. Now, this is just to give you an example of the importance of prior art searches. So, Carl Kreuer was a Danish inventor who I think in the 1960s applied for he invented something. His invention was that you can lift up. This is a sunken ship. This is the image or the drawing from his patent application. So, his invention was that if there is a sunken ship, a ship has sunken into the lake or whatever. Okay. So, this was his invention. You can fill buoyant objects, right, from the top of the water from another ship into this, so that this can be lifted up. This was his invention. So, he thought this was a fantastic invention, nobody has disclosed it, this probably is eligible for patentability, because that is what he thought. Nobody else has invented this before. But this is his invention. So, he applied for a patent, thinking that this is an absolutely new invention, filling ping pong balls, filling buoyant objects into a sunken ship, which will help you lift up the sunken ship from the bottom of the ship, bottom of the sea bed or the lake bed or whatever. But what happened, contrary to what he thought, the Danish patent office rejected his patent. Why? Because they found a very old issue of Donald Duck magazine, where Donald Duck was using the same invention to where Donald Duck was seen filling ping pong balls into the ship that was sunken to lift it up. So, this particular magazine, picture in the magazine was cited as a prior art, and this invention was refused a patent saying that this is not new. This was already thought of by Mickey Mouse, I mean Donald Duck 20 years before that. So, that is the importance, just a simple example to show you the importance of prior art searches and the importance of proving novelty in an invention. So, any prior disclosure anywhere in the world relating to your invention can be a threat to the patentability of your invention. Now, we will quickly discuss the patent filing procedure. Now, what are the information that you need to file a patent application? First of all, the applicant details. Now, you have to always understand the difference between applicant and inventor. Applicant is a person who is making the application for getting a grant of the patent. When the patent is granted, the applicant will own the patent. But who is the inventor? Inventor is a person who has actually invented the patent or invented the invention. The applicant and inventor can be the same. It can be different also. So, the applicant will own the patent, the inventor will only get the credit of being the inventor of that particular invention. So, you need the name, address, nationality of the applicant, the same details regarding the inventors, you have to give the provisional specification or complete specification, that is basically the complete disclosure of the invention. What exactly is your invention? You have to give the claims, the abstract, the drawings. You have to also specify the nature of the applicant, whether the applicant is a startup, whether the applicant is an educational institution, whether the applicant is an MSME, all those things, educational institution, all those things have to be specified. The reason being that startups, small entities and educational institutions have a fee reduction. Natural person also, yeah. So, natural person, startups, small entities and educational institutions have a fee reduction in filing patents, all other entities have a larger fee category. So, these are the preliminary information that you need to file a patent application. If you are claiming startup status, then you have to show that you are a DPIIT, you have a DPIIT certificate of recognition. If you are claiming small entity status, you have to prove it by submitting an MSME certificate. If you are an education institution, your proof of establishment. Then if you are using any biological material, your NBA approval, source of your biological material, all these things are required to be proved. Now, coming to filing of patent application. So, like I said earlier, your filing date is very important. The date on which you file your application is a date from which your protections start. The date from which the patent office says that this is your invention. So, the filing date is very important. So, which is why when an inventor comes to us for filing a patent application, we do not ask them to wait for the entire research and development to be complete to file the patent application. We tell them to file a provisional application as early as possible. Now, when you file a provisional application, you do not need to give the entire disclosure of the invention to the patent office. You need to give only a bare outline of your invention, right. And what happens after that? Within 1 year from the date of filing the provisional application, you have to give the complete disclosure of your invention. Now, the complete disclosure or the complete specification is a very detailed disclosure of the invention with all details of the invention, the drawings, the title, the technical field. You have to give a background of the invention, you have to show how the invention works, you have to describe your invention with reference to the figures that you have given, the best method of performance of your invention, followed by finally the claims and the abstract. So, a complete specification can be filed within 1 year of filing the provisional application. Now, these are timelines, these can be quite complicated, but I will quickly explain. You file a provisional application as early as possible, within 1 year you have to, so all your calculations, date calculations will start from your provisional filing date, right. Within 1 year you have to file the complete specification. If you do not file the complete specification within 1 year, your patent application will be treated as abandoned. So, file a complete specification within 1 year, within 18 months, after 18 months your patent application, after 18 months from the date of filing the provisional application, your patent will be published. Published means published in the patent office journal. So, what happens in that 18 months? For the first 18 months your patent will be a secret, nobody will know that you have applied for a patent. So, 18 months is a secrecy period. After 18 months it will be published, anybody can see your invention, get hold of your complete specification, your applicant details, inventor details, all these inventions, all these details are published by the patent office. After publication, the patent office will examine your application. Now, if the patent office has to examine your application, you have to apply for request, you have to make a request for examination. That request for examination has to be filed within 31 months from the date of filing your patent application. But in order to not to delay the patent grant process, we usually apply for request for examination immediately after filing the complete specification. You do not have to wait for 31 months, you can file the request for examination immediately after filing the complete specification. So, after you file the request for examination, the patent office will examine your application and give you a examination report. So, what will that report contain? That report will contain all the objections that the patent office finds against your patent application. It can be based on they will obviously do a prior art search, give you a report on what are the prior patents that they think can affect the novelty of your invention. If they feel that your invention does not have an inventive step, industrial applicability, if it falls under any of the non-patentable inventions in section 3, all those objections will be cited in the FER. Now, when you get an FER or the first examination report, you have to respond to it within 6 months. 6 months in LA. 6 months. You have to respond to it within 6 months. Now, when you file a response to it in 6 months, if the patent office is not convinced of the responses that you have given, they may post it for a hearing, at which time your patent agent or your attorney will represent you before the examiner, argue the matter in detail, and following the hearing you have to give a written submission, and based on that, if the examiner is convinced of the patentability of the invention, he can give you a grant. If he is not convinced with the patentability of your invention, he will refuse the patent application. So, this is the general process for registration of a patent. There are 2 stages in which third parties can oppose the grant of your patent. One is before your patent is granted, and one is after granted. So, any time before the grant and after publication, after your patent is published and before it is granted, any party can file a pre-grant opposition, and after grant also within 12 months anybody can file a post-grant opposition also. Any doubts on this? And what is the term of the patent? 20 years, and the 20 years starts from this date. Okay. So, ഈ ഡേറ്റിൽ നമ്മൾ പേറ്റൻറ്റ് ആപ്ലിക്കേഷൻ ഫയൽ ചെയ്ത് കഴിഞ്ഞാൽ ഇവിടെ വരെ എത്താൻ ചിലപ്പോൾ ഒരു 3 years എടുക്കും, ഡിപ്പെൻഡിങ് ഓൺ ഇഫ് യു ആർ എക്സ്പെഡൈറ്റിംഗ്, ഇഫ് യു ആർ എ സ്റ്റാർട്ടപ്പ്, വുമൺ ആപ്ലിക്കൻറ്റ് ഓർ എൻ എഡ്യൂക്കേഷൻ ഇൻസ്റ്റിറ്റ്യൂഷൻ, യു ക്യാൻ എക്സ്പെഡൈറ്റ് യുവർ പേറ്റൻറ്റ് ആപ്ലിക്കേഷൻ. അങ്ങനെയാണെങ്കിൽ ഇത് തുടങ്ങി ഇതുവരെ പ്രോബബ്ലി ഒരു 1.5-2 years എടുക്കാം ഗ്രാൻറ്റ് വരെ പോകാൻ. അതർവൈസ് ദിസ് ക്യാൻ ടേക്ക് അപ് ടു 5 years. But your patent protection will run from the date of filing the provisional application, and your term of 20 years is also calculated from your filing date, right. So, these are the rights of the patentee. I think we already discussed this. It gives you an absolute monopoly, exclusive rights over your invention. A very important aspect of patent is that grant kitti kazhinjal your job is not done. You have to continuously maintain your patent by paying annuity fees to the government of India. So, and that annuity fee has to be paid every year from the 3rd year of your patent. That is, 3rd year of your application filing date, continuously up to 20th year, each year you have to pay. That pay cheyidilla engile your patent can lapse. So, that is there. Okay. ഇതുവരെ നമ്മൾ ഡിസ്കസ് ചെയ്ത എല്ലാം എന്താണ്? Is Indian filing. എനിക്കൊരു പേറ്റൻറ്റ് ആപ്ലിക്കേഷൻ ഉണ്ട്, I want to get a grant in India, so I file all these things before I do a search, I file it in the Indian Patent Office and get a grant. Now, what if I want to, let us say my invention is related to AI technology or software related, and my main market is US or let us say China or European Union. How do I protect my grant? But Indian grant kittiyathukondu there is no use. Right, you have to get a grant, you have to protect your patent in that foreign country to be able to protect your invention, or to make sure that nobody else is using that invention in that particular country. So, a lot of startups, especially in the software related field work in the startups, they will file the application in India and probably in US. US is a very important market for a lot of companies in the software related invention field. Now, angana file, and how do you file an invention in a foreign country? Samayayo. So, there are 2 ways in which you can file your patent application in a foreign country. First important thing to be noted is that if you are an Indian applicant, you have to first file in India. ഫസ്റ്റ് ഇന്ത്യയിൽ ഫയൽ ചെയ്തിട്ടേ നിങ്ങൾക്ക് യു ക്യാൻ ഫയൽ എ പേറ്റൻറ്റ്. ഈവൻ ഇഫ് യുവർ ഇൻട്രസ്റ്റ്, യുവർ കീ മാർക്കറ്റ് ഇസ് ദ US ആൻഡ് യു ഡോണ്ട് വാണ്ട് എ പ്രൊട്ടക്ഷൻ ഇൻ ഇന്ത്യ, എനിക്ക് US മാത്രം മതിയാണെങ്കിലും യു ഹാവ് ടു ഫസ്റ്റ് ഫയൽ ഇൻ ഇന്ത്യ ആൻഡ് ഓൺലി ദെൻ ടേക്ക് ദ ഇൻവെൻഷൻ ഔട്ട്സൈഡ്. അതർവൈസ് യു ഹാവ് ടു ഗെറ്റ് എ ഫോറിൻ ഫയലിംഗ് ലൈസൻസ് എന്ന് പറയും ഫ്രം ദ ഇന്ത്യൻ പേറ്റൻറ്റ് ഓഫീസ്, സേയിങ് ദാറ്റ് യു ക്യാൻ ഫയൽ അബ്രോഡ് വിത്തൗട്ട് ഫയലിംഗ് ഇൻ ഇന്ത്യ. ഫോറിൻ ഫയലിംഗ് ലൈസൻസ് എടുക്കണം. അതർവൈസ് യു ഹാവ് ടു ഫസ്റ്റ് ഫയൽ ഇൻ ഇന്ത്യ ആൻഡ് ദെൻ ഫയൽ ഇൻ എ ഫോറിൻ കൺട്രി. അപ്പോൾ ഈ ഫോറിൻ കൺട്രിയിൽ ഫയൽ, യു കനോട്ട് ഫയൽ ഇറ്റ് at your wish. You cannot file it whenever you want. You have to file it within 1 year of filing the Indian application. അതായത് ഇന്ത്യൻ ആപ്ലിക്കേഷൻ ഫയലിംഗ് എന്ന് പറയുമ്പോൾ നമ്മൾ ഫസ്റ്റ് പറഞ്ഞ പ്രൊവിഷണൽ ഫയലിംഗ് ഡേറ്റ്. സോ ദാറ്റ് ഡേറ്റ് ഇസ് വെരി ഇമ്പോർട്ടൻറ്റ്. സോ വിത്തിൻ 1 year ഓഫ് ഫയലിംഗ് ദ പ്രൊവിഷണൽ, ബിക്കോസ് ദാറ്റ് ഇസ് യുവർ ഫയലിംഗ് ഡേറ്റ്, ആ ഫസ്റ്റ് ആപ്ലിക്കേഷൻ. ആ ഫയലിംഗ് ഡേറ്റ് തുടങ്ങി 1 yearനുള്ളിൽ യു ഹാവ് ടു മേക്ക് എ Paris Convention application. So Paris Convention is an international convention signed by I think about 170 countries, wherein if you want to file in any Paris Convention member country, you will have to file it within 1 year from the date of your Indian application. So for example, if my country of interest is US, I will have to file my US application within 1 year of filing in India. If I don't file it in 1 year within the date of filing in India, I will lose my chance to file in a foreign country. A same invention എനിക്ക് വേറെ സ്ഥലത്ത് ഫയൽ ചെയ്യാൻ പറ്റൂല. So that 12-month period is when the applicant has to decide which are the countries where I want to file and file it in all those countries within the 12-month time period. This is called a Paris Convention application filing. Now Paris Convention, the biggest challenge of Paris Convention that companies face or applicants face is that you have to make the decision of which country to file in 1 year. ഒരു വർഷത്തിനുള്ളിൽ ഞാൻ തീരുമാനിക്കണം where I have to file എന്നുള്ളത്. Because if I don't file it in 1 year, then I lose my chance to protect my invention in a foreign country. So അതിനൊരു സൊല്യൂഷൻ ആയിട്ട് വന്നതാണ് PCT. PCT ആരൊക്കെ കേട്ടിട്ടുണ്ട്? സ്കൂൾ ഓഫ് ലീഗൽ തോട്ടിലെ പിള്ളേരും കേട്ടിട്ടില്ലേ? ഇല്ല. PCT is called Patent Cooperation Treaty. PCT is an international treaty signed by I think about 155 contracting states including India, which allows you to file a PCT application based on your Indian application. Now PCT works very simple. PCT does not give you an international grant. അല്ല, ഒരു ഇൻ്റർനാഷണൽ പേറ്റൻ്റ് എന്നൊരു കൺസെപ്റ്റ് ഇല്ല. You have to file in multiple countries, but you can, instead of choosing the Paris Convention route, you can choose the PCT route. Now I'll quickly explain how PCT works. Slides nokanda, slides are quite complicated. See, I have an Indian filing date, which is the provisional application filing date. Our provisional application കഴിഞ്ഞു 1 yearനുള്ളിൽ I have to choose which country to file. So instead of filing directly into that country under the Paris Convention, if I file a PCT application in 12 months time, then PCT actually throws me a window open wherein I can file in any of the 155 PCT contracting states within 30 months from the date of my Indian patent application filing, right. So the advantage of PCT filing is that if you file a PCT application, you need not make your decision as to which country to file in 1 year. Instead of 1 year, you get a window of 30 months. ആ 30 monthsൽ നിങ്ങൾക്ക് നിങ്ങളുടെ ഇൻവെൻഷൻ you can market it in the foreign country because you already filed your patent application and lodged your priority. You can market, you can disclose the invention, you can see which are the feasible markets, and then 30 monthsൽ I can choose which are the countries that I want to enter into. ആ countriesൽ you have to file national applications. So that is the advantage of a so PCT has basically 2 phases. One is the international phase where you file the PCT application, you choose all the 155 PCT countries, and then a 30-month time period. This 30 months also starts from the provisional filing date. 30 months you have to decide. Let's say for example, after the 30-month time period, the company decides that okay, at the time of filing the application, they may have thought okay, my countries of interest are 10 countries of interest. But in that 30-month time period, they would have probably decided that I don't need to file it in all the 10 countries, probably my key markets are only let's say China and Mexico and US. Then a 30-month I need to file only in China, Mexico and US, and then proceed with the examination in that particular country. But obviously when you enter those countries, your patent will be examined according to the laws of that particular country. So it is not that PCT grants you an international registration. PCT will only give you a route to enter into multiple countries. Okay, this is just the benefits of patents. And first of all, the fundamental benefit of a patent is that you get the exclusive rights, you can prevent others. Secondly, it gives you a strong, if your product is a very unique product, it gives you a strong market position, higher returns on your investments. You obviously can, let's say for example, you've invented something as a part of research in a university, you've invented something, right. So, you may not have the capabilities to manufacture it, you may not have the bandwidth to market that product, you can obviously license the product to someone, license to a product to an industry partner. Obviously, for any company having a portfolio of patents, a list of patents is obviously something very positive, for a positive image for your organization, to say that I own, even for an inventor also, to say that I am the inventor and these many inventions is a positive, it creates a positive image for your invention or for the inventor or the organization. And finally, if you have invented something and you do not patent it, somebody else can patent it and then prevent you from using your own invention. So, these are the reasons why you should probably look at protecting your inventions and any intellectual property right. Any questions? പറ്റൂല. സി അതെന്താണെന്ന് വെച്ചാൽ ഒന്ന് ആറന്മുള കണ്ണാടി ആസ് എ പ്രോഡക്റ്റ് ഇസ് എ ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ. ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഇസ് ഓൾസോ എൻ ഇൻ്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്. ബട്ട് അൺലൈക്ക് ഓൾ ദീസ് ഇൻ്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് ദറ്റ് വി ഡിസ്കസ്ഡ് നൗ, ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഇസ് എ കമ്മ്യൂണിറ്റി റൈറ്റ്. അതായത് ഇതെല്ലാം ഇൻഡിവിജ്വൽ റൈറ്റ്സ് ആണ്. ഇൻഡിവിജ്വൽസിന് ഓൺ ചെയ്യാം, കമ്പനീസിന് ഓൺ ചെയ്യാം, ഓർഗനൈസേഷൻസിന് ഓൺ ചെയ്യാം. ബട്ട് ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഇസ് എ കമ്മ്യൂണിറ്റി റൈറ്റ്. കമ്മ്യൂണിറ്റിക്ക് എന്ന് പറഞ്ഞാൽ ഒരു കമ്മ്യൂണിറ്റിക്ക് മാത്രമേ അത് ഓൺ ചെയ്യാൻ പറ്റുള്ളൂ. ദറ്റ് കമ്മ്യൂണിറ്റി ദറ്റ് മാനുഫാക്ചേഴ്സ് ഓർ പ്രൊഡ്യൂസസ് ദാറ്റ്, ആൻഡ് ഇറ്റ് ഹാസ് ടു ഹാവ് എ significance, it has to have some uniqueness that is related to that geography. ഇപ്പോൾ ആറന്മുള കണ്ണാടിയുടെ അസോസിയേഷൻ വിത്ത് ദ ജോഗ്രഫി ഇസ് ദാറ്റ് ആറന്മുള റീജിയനിലുള്ള വെരി ഫ്യൂ എന്താ പറയുക ക്രാഫ്റ്റ്സ്മെന് മാത്രമേ അത് ഉണ്ടാക്കാൻ അറിയാവുള്ളൂ. ആൻഡ് അവരുടെ എന്താ പറയുക നോളജ് അക്വയർഡ് ഓവർ ദ ഇയേഴ്സാണ് അതുണ്ടാക്കുന്നത്. ആൻഡ് അവിടെ അവർ ഉപയോഗിക്കുന്ന സാധനങ്ങളും ആ ആറന്മുള എന്നുള്ള ആ ജോഗ്രഫിയായിട്ട് റിലേറ്റഡ് ആണ്. സോ ഇറ്റ് ഈസ് രജിസ്റ്റേർഡ് ആസ് എ GI, ബട്ട് ഇറ്റ് കനോട്ട് ബി പ്രൊട്ടക്റ്റഡ് അണ്ടർ പേറ്റൻസ് ബിക്കോസ് അത് ഓൾറെഡി പബ്ലിക് ഇൻഫർമേഷൻ അല്ലേ. അത് ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ്റെ ഒരു പെർവ്യൂവിലേ വരുള്ളൂ. ഇല്ല ചെയ്യാം. ഇപ്പോൾ ഫോർ എക്സാമ്പിൾ ആറന്മുള കണ്ണാടിയുടെ ഒരു എക്സാമ്പിൾ എടുക്കുകയാണെങ്കിൽ, ആറന്മുള കണ്ണാടി ഈസ് എ രജിസ്റ്റേർഡ് ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഇൻ ഇന്ത്യ. അപ്പോൾ ഇന്ത്യയിൽ അതിൻ്റെ ആറന്മുള കണ്ണാടിയുടെ ജോഗ്രഫിക്കൽ ഇൻഡിക്കേഷൻ ഇസ് ഓൺഡ് ബൈ എ ഗ്രൂപ്പ് ഓഫ് ഒരു ഫാമിലി ആണെന്ന് എനിക്ക് തോന്നുന്നില്ല, ബട്ട് എ ഗ്രൂപ്പ് ഓഫ് ആർട്ടിസൻസ് ഹു ആക്ച്വലി മാനുഫാക്ചർ ദ കണ്ണാടി. സോ അവർക്ക് മാത്രമേ ആറന്മുള കണ്ണാടി എന്നുള്ള പേരിൽ ഈ സാധനം ബ്രാൻഡ് ചെയ്ത് വിൽക്കാൻ പറ്റുള്ളൂ. സോ ഓൺലി they will be allowed to export it. But if I want to prevent somebody else from making it in another country, then obviously I have to register my GI in that country. GIയും ടെറിട്ടോറിയൽ റൈറ്റ് തന്നെയാണ്. എനിക്ക് ഇവിടെ നിന്ന് എക്സ്പോർട്ട് ചെയ്യാനുള്ള റൈറ്റ് ഇവർക്ക് മാത്രമേ ഉള്ളൂ. ബട്ട് അത് ഇപ്പോൾ പുറത്തെ കൺട്രിയിൽ മാനുഫാക്ചർ ചെയ്യുന്നൊന്നും പറയുന്നതിനൊരു സിഗ്നിഫിക്കൻസ് ഇല്ല, ബിക്കോസ് ഇറ്റ് ഇസ് വെരി ക്ലോസ്ലി ലിങ്ക് ടു ദ ജോഗ്രഫി. എന്തോ ഫുഡ് ഡിപ്പെൻസ്, അത് ഡിപ്പെൻസ്, അത് നമുക്ക് ഒരു സെർച്ചൊക്കെ ചെയ്ത് കഴിഞ്ഞാലേ പറയാൻ പറ്റുള്ളൂ. പാക്കേജിങ് ഡിഫറെൻ്റ് ആണ്. സി പാക്കേജിങ്, വാട്ട് ഇസ് ദ നോവൽറ്റി ഇൻ ദ പാക്കേജിങ്? ഇഫ് ദ പാക്കേജിങ്ങിൻ്റെ ഡിസൈനിലാണെങ്കിൽ അത് ട്രേഡ് മാർക്കിലായിരിക്കും വരുന്നത്, അത് സെപ്പറേറ്റ് IPR ആണ്. ഫുഡ് പ്രോഡക്റ്റ് നിങ്ങൾ എന്തെങ്കിലും റിസർച്ച് ചെയ്ത് ഒരു കോമ്പിനേഷൻ ഉണ്ടാക്കി അതിന് യു ഫീൽ ദർ ഇസ് എ സർട്ടൺ ഇഫക്റ്റ് അല്ലെങ്കിൽ ഒരു newness, uniqueness to that product, that combination may be eligible for patent. അത് ഡിഫിക്കൾട്ടായിരിക്കും. അത് നമ്മൾ നമ്മൾ ജസ്റ്റിഫൈ ചെയ്യേണ്ടി വരും, ബിക്കോസ് ദാറ്റ് ഒബ്ജെക്ഷൻ വിൽ കം. സി ഫുഡ് പ്രോഡക്റ്റ് റിലേറ്റഡ് ഇൻവെൻഷൻസിന്, ബിക്കോസ് അതെല്ലാം see probably I don't know, I am not discouraging you, probably your newness is in a എന്താ പറയുക, ചിലപ്പോൾ അതിനൊരു അളവിലായിരിക്കും നിങ്ങൾ വ്യത്യാസം വരുത്തുന്നത്, എന്തെങ്കിലും ഒരു അതൊക്കെ ചിലപ്പം പേറ്റൻറ്റ് എലിജിബിൾ ആയിരിക്കില്ല. that can be patented. Processൽ if there is anything new in the process that is being used to manufacture that food product, that can be existing. അവിടെയും novelty is a criteria, irrespective of whether it is a product or a process, novelty has to be there. അത് നമുക്ക് സെർച്ച് വഴി, പ്രയർ ആർട്ട് സെർച്ച് വഴി to a large extent we can assess novelty.
Prior art search ചെയ്യാൻ best
ഒന്ന് ഗൂഗിൾ പേറ്റൻസ്, USPTO, EU IPO, പേറ്റൻറ്റ് സ്കോപ്പ്, വേൾഡ് ഇൻ്റലക്ച്വൽ പ്രോപ്പർട്ടി ഓഫീസിൻ്റെ ഡേറ്റാബേസ്, ഇതൊക്കെ ഫ്രീ ഡേറ്റാബേസസ് ആണ്. വിദ്യയൊക്കെ യൂസ് ചെയ്യുന്നത് പെയ്ഡ് ഡേറ്റാബേസസ് ആണ്. അത് ഈ പേറ്റൻറ്റ് അറ്റേർണീസ്, പേറ്റൻറ്റ് ഏജൻസീസ്, പേറ്റൻറ്റ് സ്കോപ്പാണോ നമ്മൾ യൂസ് ചെയ്യുന്നത്? പേറ്റൻറ്റ് സ്കോപ്പ് പാറ്റ്സിയർ ആണ്. പാറ്റ്സിയർ പേറ്റൻറ്റ് സ്കോപ്പ് അല്ല, പാറ്റ്സിയർ, പാറ്റ് ബേസ് എന്നൊക്കെ പറഞ്ഞ് പെയ്ഡ് സോഫ്റ്റ്വെയർസ് ഉണ്ട്. ബട്ട് ഇഫ് യു ആർ ലുക്കിംഗ് ഫോർ free databases, go for the patent databases of different countries. അതിൽ USPTO is free. European Union database is called eSpaceNet. eSpaceNet free ആണ്, USPTO free ആണ്, Indian Patent Office IPO database is free. Google Patents search ചെയ്യാം, അവിടെ രജിസ്റ്റർ. ഗ്ലോബൽ രജിസ്ട്രേഷൻ ഉള്ളത് PCT ഫയൽ ചെയ്തത് കാണണം എന്നുണ്ടെങ്കിൽ യു ക്യാൻ സെർച്ച് പേറ്റൻറ്റ് സ്കോപ്പ്. അത് വേൾഡ് ഇൻ്റലക്ച്വൽ പ്രോപ്പർട്ടി ഓർഗനൈസേഷൻ, WIPO പേറ്റൻറ്റ് സ്കോപ്പ് സെർച്ച്.
Let me introduce myself. I am Dr. Robin Jacob. Basically, I am a professor of a School of Tourism Studies and also in charge of this NGO Innovation Foundation. And I am in charge of Internal Quality Assurance Cell of Mahatma Gandhi University as its director. So this whole system which you see in this panchayat, why I am highlighting panchayat, because we are in a rural area. We were able to establish this facility because of the high ranking and accreditation of Mahatma Gandhi University. So any institution, any higher education institution, its stakeholders, all basically stakeholders are students and faculty members. Human beings make changes in every institution. So their hard work made a lot of difference. So this is a unique effort by this public institution to make entrepreneurship and innovation a successful endeavor even in Tier 2 and Tier 3 cities. So statistics say that 49% of the startups in the country are in small cities, Tier 2 and Tier 3 cities, and we are actually in a panchayat. So anyway, we are very happy that people from representatives from different institutions, people representing different higher education institutions who are potential innovators are here. NGO Innovation Foundation is basically focused on a few things. We have another institution called the Business Incubation and Innovation Center. They are dealing with IEDC clubs, prototyping, tinkering labs, managing, the ideation stage. While this NGO Innovation Foundation deals with the second phase, the incubation phase. Those who want to commercialize their product with a viable, innovative idea, they are welcome. And the first phase of facilities are here. The institution is in the verge of developing itself with its second stage of facilities. So anyway, I'm thankful to Dr. Parvati for the great interaction with the people who came from different places, and I hope people with recently we had announced a big idea competition. So those who are with good innovative ideas and those who are able to team up with passionate people are welcome. In the case of such people, such passionate innovators, this public institution is ready to support you with in the form of seed funding, scale up grants, registration formalities, IPR support in IPR, then even meetings of angel investors, so many things. So, like the common facilities available here, like the high performance computing system which is listed in the iSTEM portal of Government of India. So the co-working facilities, there's a pilot spray dryer and all those things. So you can make use of these facilities, and we wish you all the best. And I sincerely thank Advocate Parvati for her wonderful contribution, and I thank you for your wonderful presence here. Thank you.
Thank you all for coming, and we will see you in the next workshops that will be coming soon. Thank you.